Viking lawyer's got a brew in hand, streaming wild cases across the land. A courtroom circus, a legal ride, slightly buzzed on justice and a Viking's pride. Objections flying, gales a swing. Nick just laughs, oh, what a thing. It's a slightly buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Mugshots rolling like a movie reel, a pizza thief or a banana peel. He calls it absurd, he calls it wild. Your Honor, is this trial on trial? Raise your glass to the streaming king, a Viking lawyer with a legal zing. Don't sue me for fun, I'm here for the lore, and maybe one more drink before we explore. It's a slightly buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Hear lawyers glare.
Hey, yo, folks. As you might have noticed, a couple of minutes before the stream started was when the thumbnail was revealed. Yes, today's topic is the one who cannot be named. Because somehow one of my two prior videos about the cases involving the person who may not be or cannot be named, she managed to take down one of them. And
Cher has always been evil. I mean,
yeah.
Damn.
Florida Sunshine Laws didn't matter. First Amendment didn't matter. My Swedish freedom of press law didn't matter. It was still taken down. So, hence, can't name the name. Everybody, or most of you might know who we are talking about. But what we will have before you is the latest hearing. So that is public. It was a public hearing. The recording is public. Now, this specific recording magically appeared in my computer. And so, but it's still public. So I will actually make a banner. Everything you are about, everything you are seeing is public. And protected as such under Florida Sunshine Law. Scroll across.
Oh, see, I would just go full Mo and just say, like, everything in the Church of Mo is validated by the laws of Mo and undersigned by, Newtonian science.
Yeah. Now, this here is not towards this person. This is because it will be, I assume it will be attempts to take this down. Then at least I will have the banner. I have my statement. Everything you're about to see is public court documents.
Yes, and I am just
hearing.
here to judge and be a redhead. So
Yeah.
I was there.
Yeah.
Ooh,
Sweet.
Threatened me with lawsuits and even sent me the lawsuit. that she intended to file against me. I decided I had a little stake in this case, so I clicked the WebEx link.
Ooh, fun.
And I watched it live and took notes. Copious notes. Not 19 pages like Mo would have, but enough.
Okay, but in all reality, like that is a defense mechanism, and 40 to 70% could be just gross ad hominem attacks.
Yeah.
I did have one. I had vocal fry, so
free speech. Free speech. Free speech. Now, what of course, the Wheel of Regrets is slightly modified because we still have a few from last week.
Ooh.
Yeah. So we have shots, coffee, butterfudge, apple pie, sour S, and glitter fizz. Now, since these are only half shots, it is $25 per spin. So that is, yeah. Oh, look at this. 250 joules, Laughing Disco. I'm still not entirely sure what every joule is worth, but I take them all. I will take them all. And what I do have, if I remember correctly, from yesterday. Where is it? Where did it go? There, Granny Smith bought 5 coffees at the end of my last stream a couple of days ago, and I didn't see it until afterwards. So 5 coffees are $25. So we will start the stream with a spin on the wheel. Dun, 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 dun.
That actually sounds really good.
Now, all of this was from the shot box with originally 8 different flavors.
You have a shot box? Where'd you get that from?
Well, when I say local, it's about a half an hour away. That's glitter fizz. I did say butterfudge, yeah, which in Swedish is smörkola. Let's find myself a clean shot glass. There is one. Out of Utah. My microphone has started to unplug itself again, which means I have to buy a new cord. Dun, 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 dun.
That looks really good, actually.
Cheers!
I feel like you need a drink in order to talk about this person.
Oh, definitely.
This person drives you to alcohol.
So yeah, folks. For obvious reasons, I haven't mentioned her name yet, but it will be named in this public hearing recording. Okay. So let's.
Has she ever heard of the Streisand effect?
No.
She doesn't care about the Streisand effect.
It wasn't like a small story. In fact, it's somewhat of a cautionary tale.
Yeah. Now, for you who saw the thumbnail, you noticed that it showed the back end of a baboon.
Devent, you saw that I called her Voldemort in my stream because she gets mad when you say her nickname. So I gave her a nickname meaning the one who shall remain nameless, and called her an old, wrinkly looking dude.
And that person in the middle Yeah, that's her.
Okay. Ma'am, did you realize that your wig isn't laid properly? No, I do this in front of a mirror. Because if you get it just a little bit
sat in front of a
wrong,
mirror, it'd break.
Her mouth was graped by a Dyson. I mean,
Also, how much Vaseline have we put on the mirror? I mean, we are going Joan Crawford dynasty levels here. I mean, has to be at least 3 inches thick here.
yeah. Now, Squid, could you give the elevator pitch on what is this hearing about?
This hearing is to label the Voldemort character in our story a vexatious litigant under Florida law. Because in her past, she has sued the Florida bar. She has sued her former paralegal. She has sued her mother, her in-laws. She has sued Jeremy Hales, Megan, Tug, and Jay Hip for defamation. She has sent out tens of hundreds of cease and desists, including one to yours truly. She has a history of on camera saying, I file lawsuits to get them on the record, and then I dismiss them because I don't want to go through the court system.
Yeah.
You have got to be kidding me. Is there like an archetype for evil perimenopausal women? Like, was there a sale on this particular facial? Did I miss? I swear to God, I didn't think I'd have to pull these out tonight. But Jesus. Again, between her, Matthias, and Moo Cow, what the hell? Ladies, pick a different look. Just a unique one at this point. I'm going to have to buy new eyebrow stickers. Mr. Mo has severely lowered my brow budget.
I've been needing to ask you, where did you get those?
There's $7, but you have to get them in a pack with a bunch of fake beards.
Yeah, it's caterpillars. Also, this person in the middle there is a retired attorney. She retired after she was reported to the Florida bar after allegedly not giving a shit about her clients and getting her clients into legal trouble, including but not limited to fines for not appearing on hearings she didn't tell her clients about. But in order to avoid punishment from the Florida bar, in my opinion, she voluntarily retired with a promise of never practicing law again. How many have she sued so far through with the help of but she does it as a pro se litigant. So she technically is not practicing law.
I think I have seen some of her filings through Shizzy, and I have seen more coherent things from Daryl Brooks. So
Sarah Boone was a better writer.
What school did she say that she got her JD from?
She went to, and I can't remember. However, her lawyer and my lawyer were in the same class, so it's not the law school, because he works at one of the top 50 law firms in Florida or in Orlando. So it's not the law school; it's person. They actually graduated together, which was even more fun for her to find out. So
let's have a listen on this hearing where people are attempting. Well,
before we start the hearing, can I give you a rundown of the notable people who were listening to this hearing?
Yes, please.
Kyle Fletcher, which was one of the other plaintiffs in when she sued the bar, and was also a lawyer representing one of the clients who sued her for malpractice in Pinellas County, Florida. There was also her mother was in this, and her brother-in-law were observing this hearing. In addition to a bunch of, the regulars, Shizzy, Tug, Megan, Rackets, and paint chips. which is Luthman, a disbarred lawyer who's on her side.
Oh,
yeah.
Well,
was he the rather portly gentleman who canted his chin thusly to appear as though he had one?
Why does he have a Christmas tie on? Who is that?
That in the bottom right is Jeremy's lawyer. That is Randall Shockett.
Okay. Still, why do you have a Christmas tie?
I will be right back. I have to go put water in the flosser.
Of course you do. Yeah.
Yeah, we have
right. Yeah, but you already seen this. You saw this live. I haven't seen a second of it. Folks, let me know if you can hear sound. Here we go. That is the highest volume I can get on it.
Nick, I'm not hearing anything. Do you have it on the right window?
I have it on a media player. Maybe I have to... Hold on.
Because if you're hearing it, I'm just not hearing it.
Okay, hold on while I find it as it appeared on my computer.
Ah, good idea.
Dun, dun, dun. There, and let's go take that down. Here we are. And
I need alcohol for this.
Share screen.
I felt like that at 6 a.m. this morning, and I don't generally drink.
Full volume. Let's go forward. Forward. There we are. Volume enhancer. Here we go. Dun, dun, dun.
Today,
we can hear.
I have an amended motion to declare Leslie Federico's a vexatious litigant set by the court. And so counsel for the plaintiff.
I got it.
For the record.
Good afternoon, Your Honor. Randy Shockett, Shockett Law Group in Trenton, Florida, on behalf of the plaintiffs.
Oh, Megan showed up.
And on behalf of the defendants.
Good morning, Your Honor. Leslie Federico's on behalf of myself.
Good afternoon to both of you. All right. So we have.
Excuse me, Your Honor. I'm the court reporter on the net, and I'm getting a lot of reverberation.
I just need everyone.
This is Olivia Gardner with Esquire Solutions, also here for this matter.
Okay, so this is the plaintiff's motion. Who was hired by the plaintiff?
Your Honor. I'm also a court reporter here.
Wow.
So who was hired from Mr. Shockett? Who did you hire?
Who did we hire? Do you guys, who, I think it's, yes, I think that's right. Lynn,
That would be
Ms.
me,
Blossom.
sir.
Yes, sir. Yes,
Yes.
ma'am, I remember you. Yes, hi.
All right, so, Ms. Blossom, what agency are you with?
Powers Reporting. POWERS.
All right, thank you.
Yes, ma'am.
Okay, just for the record here, I have linked to my Rumble stream because there is a risk the stream on YouTube will be taken down. So if this goes dark, head over to Rumble. You don't have to register for watching, but you have to register to chatting around. But you can still watch this show over there. It is pinned at the bottom or the top of the chat, depending on What I don't know. Sometimes it is in the bottom, sometimes it's on the top. Regardless, member for 36 months, Wim 106. Where he is. Wow. Where she is. Sorry. Yeah. So, with that warning, let's go again.
Miss Puerto Rico's, who told me that you're a reporter as well. Are you comfortable?
Yes, Your Honor. It's court reporting specialist. I was given the first name Leslie, who is handling it.
Good afternoon, Your Honor. I apparently am the third court reporter. I just want to make sure I'm the right path.
Okay, we don't need that many. So I believe Ms. Blosser was on, she's been hired by the plaintiff. And Ms. Federico's, who did you hire?
I hired Leslie from court reporting specialist, and I already paid for this because I had to prepay. So
And then I didn't have any problem.
And not to have any confusion, but Olivia Gardner with Esquire Solutions, hired by Michael Fredericos.
oh, I think from my understanding it was canceled. It wasn't confirmed because there was a double booking. So that could have been the confusion.
So I'm excused, correct?
Yes.
Okay, have a good one.
She seemed very relieved. Oh, this is a clusterfuck.
Are she and Michael still together? Why is Michael getting his own court reporter?
They've been on, off. There's been reports, or they said they have a pending divorce, and then it's been reclosed, and then opened, and then reclosed, and then opened. Who knows? She called 911 on him one time for shutting off her internet.
Yeah.
Yeah, like I said, she makes low-cow look sane.
Guys out there, it might be fun to stick your dick in crazy, but it's never worth it. And there's not a person alive that gives this good of a BJ that would render you stay with her. It's impossible.
This may seem like I feel like this is a scary question, and I should just stick with my headcanon of Agra from the Dark Crystal. But do we happen to have footage of this woman without the 900 pounds of Vaseline on her camera?
Yeah, probably, but I won't show it because that would be one of the things. Personal things like full name and image.
So it's more preferable for her to have me have my mental headcanon be that she is in fact the doppelganger of Agra, the trash muppet from from Dark Crystal. I like this strategy, ma'am.
Oh, in the thumbnail that I used, when I used a thumbnail or a picture that she had used on her website, that is the closest to the real person that, yeah. Well, and this is and with this whole thing, I don't like either side. So I was just covering the documents because the court case interests me, not necessarily the people.
Yeah, and I covered the bar complaint.
But when she introduced herself, it was like, this is just odd.
Oh, mini squid. Okay, let's continue.
Ms. I'm sorry, Federico's. I'm with court reporting specialist.
Yeah, that was you're Leslie, correct?
Yes, ma'am. And I'm still getting reverb and feedback.
Turn your device off, Ms. Shaw.
I was getting it without it being on, ma'am.
I see someone on named David. I need everyone to mute their devices. Are you still getting that feedback, Ms. Shaw?
Yes, ma'am.
You're the only one that's on. I don't know what to tell you, Ms. Shaw, but,
It's better now, Your Honor.
oh, okay. All right, so, Mr. Shockett, I've received your motion, your amended motion to declare Ms. Federigos a vexatious litigant. In your motion, you have attached docket pleadings of various cases. You may begin your presentation.
Your Honor, if I may, I'd request to do an opening if I could, and also I was not provided any witnesses from Mr. Shockett, but if he intends, I would invoke the rule of sequestration. However, this is a matter of law, and that's why it's really important to know what statute we are going by, because it would determine whether or not evidence was relevant or not. And that was, but I wanted to give an opening to put on the record.
That you should have brought up before the hearing. But she does it during hearing because it's interrupting.
Look at Megan's face. Megan's like, I swear Megan has the glasses on so that she doesn't have to to hide her what the fuck face.
Yeah.
Legitimately, sometimes if I know I'm going to be rolling my eyes, I'll wear the bigger glasses because I know it's very disrespectful. Or if I know I can't have really a big poker face, I'll wear bigger glasses or do something funky with my hair because I know that'll distract-ish.
Yeah.
Today, if I could.
In the motion, it states Florida statute 68.093. So you were on notice about that. I only have 1 hour just dedicated to this. And so I wanted to make sure I hear both of your arguments as opposed to listening to an opening statement. So I prefer to just hear from you, Mr. Shockett. Then I will give you an opportunity, Ms. Federigos, for you to have a chance to respond. And because Mr. Shockett is the plaintiff's attorney, he brought the motion and carries this burden, I will have him in with his reply at that time. So both parties will be able to make their statements. Mr. Shockett, let me hear from you first, please, sir.
All right, so Your Honor, should be clear. Thank you, Judge. 30 minutes aside, that's what I was thinking, right, for the 1 hour.
30 minutes aside.
Okay, and my only witness is Ms. Federigos, so she's here, and she doesn't need to be secluded. So, okay.
Maybe she
Judge,
should.
we're here today on our amended motion to declare defendant Leslie Federigos a vexatious litigant under the statute you've pointed out, 68.093. The purpose today is evidentiary, but it's very narrow. I know we're down to 30 minutes. We're here to determine, and we're going to show that Ms. Federigos meets at least two of the section 68.093's definitions of a vexatious litigant. The definitions, as Your Honor knows, includes persons who repeatedly file unmeritorious pleadings, requests for relief or other documents, conducts unnecessary discovery, or engages in other tactics that are frivolous or solely intended to cause unnecessary delay in any action. That's the main focus today. We also will show that she repeatedly files pleadings, requests for relief or other documents, and I'm reading from the statute, Judge, on definition of a vexatious litigant, that have been the subject of previous rulings by the court in the same action. And in these cases that we're going to show you are going back 7 years. She's pro se on almost all of them, except for the most recent one. And these have been include cases which have been finally and adversely determined against her. And whether this court should impose the safeguards, which is what we're seeking, that Florida law authorizes to protect the judicial system, Judge, and opposing parties from further abusive litigation. So, Your Honor, the statute changed, as you know, July 1st, 2025. It greatly expanded the statute's reach for courts in two critical respects. First, it extended the look back from 5 years to 7 years. And second, it expressly included now actions governed by Florida family law rules of procedure within the definition of action. These amendments operate remedially and procedurally. They do not create any new substantive rights or penalties. There is no such thing as a right to be a vexatious litigant. That's where we're at. So we have the cases, you have them, Judge. Most of them are actually in your court system. The cases, they have the exhibits there. There's only 2 cases that we added that are not in this court. One of them is an appellate decision, which we handed to you in our exhibit book. And the other one is a federal court docket that was in a case which Ms. Rodriguez filed pro se, and it ended against her. So you have 4 family law injunction petitions filed pro se, all dismissed or voluntarily dismissed. Your Honor, just to save time, do I need to give you the case numbers, or you can? Okay, thank you, Judge. There's.
I wanted to put this on the record.
I don't appreciate being interrupted. I really don't, Judge.
I'm allowed to do a legal objection.
Ms. Federigos, this is how we're going to do the hearing.
Okay.
This is Mr. Shockett's presentation. If you want to put something on the record, you are more than welcome to do that on your turn. But do not interrupt.
I wasn't sure if he was admitting evidence, and because I did object to the exhibits that he did.
Ms. Federigos, it would do you well, ma'am, if you would just wait your turn. I will hear from you, but I do want to hear from Mr. Shockett first. Do not interrupt him again. Let him make his presentation, and I will be expecting him not to interrupt you when you make yours. Mr. Shockett, continue, please.
She can't help herself. She really can't.
I like how she's like, I'm allowed to make a legal objection.
And the judge says, no, this is not this type of hearing. You address it on your time. What I hope is that the judge will deduct this from her time.
What I will say is she got better after that. But I think this, you can see where she bites her tongue or bites her lip for.
I don't know if she can. They are so far out. I mean, she can only bite her lips if she has buck teeth. I mean, and I doubt her teeth are original. Let's continue.
Take care of your wig.
No, but every time she puts her glasses up there, it will slide slightly backwards.
Yeah, but I mean, you have to wash them. You have to treat them. That looks all clumpy. Like she hasn't taken care of it. See, I knew I could add something to today's stream.
And Megan is, oh yeah, go get her, but you can't say it.
So we have 4 family law injunction petitions, 2 civil defamation actions, 1 guardianship appeal, and 1 federal civil action. The 4 family law injunctions are 2 stalking injunctions and 2 domestic violence injunctions. All of these were dismissed. One of them was dismissed after a final hearing. The other ones were voluntarily dismissed and dismissed by the court. The 2 civil defamation actions filed by Ms. Federico's pro se all ended without relief for her. And after extension litigation, one of them, and another one where she failed to perfect service. There's also a case which is the subject matter of this lawsuit for malicious prosecution, a case where she dismissed. She filed another defamation lawsuit against these same plaintiffs, which she dismissed last year after the defendants were never even served. The guardianship appeal was filed pro se, resulting in an adverse appellate mandate against her, issued by the 2nd DCA, January 19, 2024. Lastly, there's a federal civil action where Ms. Federico's filed a lawsuit against the Florida bar, and that was also dismissed for lack of subject matter jurisdiction. So, Judge, these are not isolated events. They represent a sustained pattern of initiating litigation, consuming judicial and party resources, and then abandoning the cases or losing them outright. Florida law is clear that statutory inquiry focuses on whether actions were filed and ended adversely, not on the litigant's subjective motivations. And on that issue of Ms. Federico's subjective motivations, she stated publicly, and I quote, and we'll show it to you now, quote, and this is in the last 2 years. I've done things before where I have had people say things about me. And what I've done is I filed a lawsuit and then I withdrew it. I filed it just to get it on the record, just as soon as it becomes public record at that point. So if you know, if I'm being defamed or something, I can file it just enough to, if you look up my name up, you can see, you know, whatever, and then I withdraw it because I don't want to go through the court system. I'm going to play that for you right now, Judge.
Dun, dun, dun.
Hold on. Sorry.
I have been had people say things about me.
You can't see this. You can't see what I'm doing, right? Is there any way for me to show this to you, Judge? Sure, I think there is.
I was never given this prior to this hearing, according to your procedures, Your Honor. We were supposed to exchange exhibits. I was never, this is due process. This is a trial by ambush. He's literally presenting an audio that was never submitted to me, never given to me so that I can prepare.
It's your, it's you. You said this. You don't need it sent to you.
Bless your heart, Pumpkin. Everybody has this. Tug put it on his Facebook. Everybody has it. I have it. My lawyer has it, Princess. Everybody has it.
Yeah.
She told my lawyer that she didn't expect anybody to see it. His response, you did an interview and you didn't expect it to be disseminated?
Yeah.
Rebuttal evidence.
Judge, this link is in my motion and my memorandum.
And he ignores her. He just, she's done talking, and he keeps talking to the judge. Good choice. That will infuriate her.
Which was provided to her.
Please continue, Mr. Shockett.
Thank you. Will do. I think this is the right one. Everybody see that?
As obnoxious as
Oh
she is.
my God.
What in the...
Have y'all never? Oh, you guys have never seen this before? Oh my God!
What the fuck is that?
I feel like I need holy water.
Hold on. Let's see.
Does anyone hear that background Gregorian chanting from Damien or from Omen?
Did I match the energy?
I don't know.
God, I hope nobody screenshots that and sends it.
I need, Lord, help everyone.
What in the actual fuck?
Whoop. I'm getting a oh, my next cease and desist is already in the mail. I can see it already.
And now, this recording, that at least this narrow recording, is public, officially.
All right.
Before where I have been had people say things about me, and what I've done is I filed a lawsuit and then I withdrew it. Yeah, I filed it to get it on the record, just as soon as it becomes public record at that point. So if, if I'm being defamed or something, I can file it just enough to, if you look my name up, you can see, whatever, and then I withdraw because I don't want to go through the court.
Okay, continuing now, Judge. That what you just saw and what you heard her say is not a correct use of the court system. Those are not meritorious pleadings. And remember, a vexatious litigant is one who repeatedly files unmeritorious pleadings, requests for relief, or other documents, conducts unnecessary discovery, or engages in tactics that are frivolous or solely intended to cause unnecessary delay in any action. Her public admission right there that she files lawsuits solely to create a public record rather than to litigate constitutes clear evidence of engaging in frivolous tactics and utilizing the court system for an improper purpose. That's the definition included as a vexatious litigant. So now, Judge, and by the way, last thing before I call Ms. Federigos. If you look at the docket in this case, Judge, you'll see this lawsuit itself demonstrates her pattern of being a vexatious litigant. Because since she appeared May 15th, there are now 40 plus filings filed by her pro se. I don't know if you know, she also sent about 7 or 8 emails in 2 days, beginning July 20th and to July 22nd, to Your Honor's judicial assistant as a pro se litigant. So, Judge, I'd like to call Ms. Federigos to the stand, put her under oath.
Ms.
Dun,
Federigos,
dun,
please
dun.
raise your right hand.
Oh, she has 5 fingers.
That the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth to help you God.
I do.
And Ms. Federigos, you are a retired attorney, correct?
Correct.
Hold on just a second. I've let some new people in to the room. If you were just recently entered into the room, I need you to mute your device, every single one of you, because it gives feedback.
That is Luthman.
Mr. Shockett?
That is the one referred to as paint tips. He is the
Ms.
disbarred
Federigos, you
lawyer.
are a retired attorney, correct?
Correct.
You were admitted to the
Where
Florida
are you-
Bar on
what
April
is going on
22nd,
here?
2017. Is that correct?
I would have to look that up.
Oh my God, Nick, pause.
And you chose to permanently retire.
Someone better keep an eye on the guy in the blue shirt. He is getting ready to sell embryos to Jurassic Park's competitors.
Just wait.
He's going to
He's
screw
in the
over
vehicle. He
Jurassic
gets in a
Park.
vehicle with a kid later. Kevin, he got in because it was a public WebEx link. I was there. Like DJ Radis was there. Like you could see DJ Radis was there. Like it's a public WebEx link. There was over 50 people that were there. You didn't have to be a party to this case to view it. You just had to, if you weren't a party to the case, keep your damn mouth shut and keep off camera. But apparently, even Michael Federigos kept his camera off. And he's a party in this case. He kept his camera off and his mouth shut. Because this had nothing to do with him.
Permanently retire from the Florida Bar on March 13, 2023?
Correct.
So you're not a regularly retired attorney. Instead, you are an attorney who was approved for permanent retirement. Isn't that true?
I was approved for permanent retirement, correct?
Do you know, as an experienced attorney, that a regularly retired attorney may petition to return to active status, whereas an attorney approved for permanent retirement is barred from ever being reinstated or readmitted to the practice of law in Florida?
Correct. Yes.
All right. And you currently assist your husband's law firm with legal research and drafting?
Not correct.
Bullshit. There's a clear difference between the legal filings he writes and she writes. It's in the tone.
Well, also, don't hers have borders? Like as a formatting setup, don't hers have like these linear borders sometimes?
Yeah.
Unfortunately. Yeah, it's the
Yeah.
weirdest thing I've ever seen in my life.
All right, let's talk about one of the first stalking injunctions. On February 25th, 2021, you filed pro se petition for injunction for protection against stalking against Steve Philadusa, correct?
Correct.
And May 24th, 2021, the court dismissed that petition after a full hearing, correct?
Correct.
And you represented yourself pro se in that case, right?
Correct.
And your request for a permanent injunction, your petition was denied, right?
For permanent, for ex parte, it was granted.
All right, let's talk about another stalking injunction that you filed against someone named Chartine Vieira. On March 3rd, 2021, you filed.
That was her paralegal.
Correct?
Yeah, her own paralegal.
And was
That was-
her paralegal defaming her how?
Because I believe it had something to do with her case with the Florida bar, that she testified or she wrote something to the Florida bar, and I can't remember the exact specifics. All the different cases, I have all of the documents on my computer. They're just all running together at this point in my this saga.
Okay. It is a Friday. I remember bits and pieces because I will like randomly go through and catch bits and pieces from you, but I'm never quite sure if I'm remembering the right thing from the right case. So I may ask some dumb questions.
I paid attention to her from the very beginning, and then she called me a felon because I read legal documents and I'm not a lawyer, even though I never claimed to be a lawyer. And the documents I get are publicly available. She called me a felon. So I said, instead of me suing you, I'm going to read your publicly available documents. And she, about a month and a half ago, sent me a cease and desist from being pissed off about a stream from like 3 months ago.
Yeah.
So
I'm expecting one fairly shortly.
It's been a situation.
Yeah.
The browse will not go unnoticed.
Thank you, Emotional Lemonade, before becoming a member. Thank you so much. Now you have access to my members-only content, and you get to see videos before I publish them publicly. And you have your own emojis here on YouTube. Thank you so much. Brings us closer to the next spin on the Wheel of Regrets.
Correct.
Now, as an experienced attorney, you know, in Florida, a stalking injunction requires you to state under oath in your petition that you have a reasonable fear of imminent harm. True?
True.
And you voluntarily dismissed that case before a hearing was held, correct?
Correct.
You claimed you could not serve the respondent in that case, right?
I could not serve the respondent due to, and I admitted this into my evidence, due to her bringing a handgun, and the process server could not get her.
Oh yeah.
Wait a minute.
Sidebar. She sued the process server who was going to sue her for her foreclosure, or who was going to serve her for her foreclosures because she knocked too hard and intimidated her family. So she sued ABC Legal. That was another one. I'm surprised he doesn't bring those up because those got dismissed because she didn't show up for hearings.
Oh.
But he doesn't bring those up. Yeah, I'm kind of mad.
And let's see it. If her paralegal put a gun to the process server's face, we would see a police report.
Absolutely.
And she is good at dropping police reports because she accused Jeremy Hills of SA and dropped that police report.
Yeah.
Like I said, I don't pay attention to most of the drama. I'm not even a Jeremy Hills subscriber. I just pay attention to the documents because the case itself, I wanted to know if the court system would take online drama seriously. Because
in what universe, ma'am? You're like legitimately, and no, okay, I mean, you can be a cougar, but aren't you like 20 years older than Jeremy?
Yeah, she sent me an email. So she posts under sock accounts, lots of them. But she has one that is David Jones. If you're going to troll a Navy vet, that's the way to do it, using a kind of creative but stupid. But when she sent me this email saying that if I don't get justice in the court system, I'm going to cyber harass you for a year, she attached the original pictures that she posted on Facebook under this David Jones account, except they were attachments from her computer, not screenshots from Facebook.
Oh.
So what did I do? Made an IC3 complaint. She got real quiet after that one. 2 local police reports and an IC3 complaint. And a friend of mine that worked for Florida Department of Law Enforcement, his wife had a meeting with someone in Georgia and they got a hold of GBI for me. So and GBI is the Georgia's Bureau of Investigation. So
I know way too much about them since the YSL trial, which I covered for 2.5 fucking years.
So I don't know anybody, but apparently some people that I know people.
Yep.
It's just it's so incredibly maddening because and I'm just a person who dabbles in, like, kind of remains on the outside orbit. But there are so many cases that, people are really waiting for these things, life-saving things like I'm fighting
Yeah.
for insurance after the hurricane, or,
Yeah.
real life things. And she's using it to make sure people don't say mean things on the interwebs.
So, not to promote my own channel, but I have a whole loose lips playlist which is not anything related to Hales. It's just her lawsuits.
Yep.
All her lawsuits.
Yeah. So go over to Squid and subscribe to her. And so if you want more of lips.
So if you think this is entertaining and you think she is entertaining, but you don't want any part of any of the other drama and you just want information about her, I have information about her. Because when she called me a felon, I said, I'm not going to sue you because you have nothing, 2 houses in foreclosure and all. I'm going to read your legal documents for entertainment.
Yep.
And she got mad.
Aw.
Get her served.
But you claim you could not serve the respondent, right?
In that case, yeah, there was 2 cases. I know one of the cases I could not serve her in.
Okay.
I would have to go back and decipher which case. There was a civil case and then there was an injunction.
So you are now admitting to the judge that there are more cases against the same person? Yeah. I bet the judge would take notice of that you voluntarily submitted information about more lawsuits you made. For fuck's sake.
She tells on herself all the time throughout this.
Wow.
Oh, I can't wait to get to one part. I have something so good to share with you.
I could not get her served.
Okay. Now, if a temporary injunction that you get ex parte, if that's dismissed, it will close the case. True?
Correct.
But here, as an experienced attorney, don't you know that if you can't serve the respondent, then the temporary injunction remains in place, right? Until their service, correct?
Correct.
So when you voluntarily dismissed this petition, you did so in good faith, right?
Yes, I did.
Meaning that you were safe enough to dismiss the case. You no longer had a reasonable fear of imminent harm, right?
Not at that point. No, I did not. That's why I voluntarily dismissed it.
What?
Okay. The threat from Miss Vieira.
Why do I keep hearing Laura Owen's voice in this?
This is so in the chat. Queen said this is what would happen if Amber Heard had her law degree. No, this is what would happen if Laura Owens had her law degree.
Yeah. No. Regardless of what you think about Amber Heard, she is smart. She's just a really, really shitty actress. These guys, like her, Laura Owens, and this woman was smart enough to go through to get a law degree and then absolutely waste it. And Laura Owens
you look like Edna from The Incredibles.
I am. First of all, I keep waiting for her to break out in Meredith Baxter, I'm a bitch, I'm a lover, because that's what her background is reminding me of. And she's not said anything salient, on a cognitive level. So I find myself trying to make sense of her background and her atrocious wig. Take care of your wigs, ma'am. They will take care of you. Wash that. Damn.
Was no longer imminent, even though you hadn't had any service perfected, right?
Yes, due to situations that happened outside, I no longer felt threatened and I was not going to waste the court's time with the hearing, so I voluntarily dismissed it and the court adopted that dismissal.
Right, the order dismissing your petition for permanent injunction was entered, true?
Just adopting my voluntarily dismissal, yes.
Yeah. Let's talk about another case you filed against Ms. Vieira, a defamation action, and others. You filed it on March 1st, 2021, pro se, correct?
Correct. No, I'm sorry. That was from my law firm on behalf of my business as well. and myself, and there was 3 other attorneys that came into that case. And at the time it was dismissed, there was another attorney on the case as well from the law firm. It wasn't just me.
Let's break down very carefully, and be careful, you're under oath. You filed this petition, the complaint in that case, pro se, by yourself. You signed the complaint yourself, correct?
It was also on behalf of my law firm because it was a business. Leslie Ann Law was a business, and my law firm, as me as an attorney for that law firm, represented that business. And on top of that, for the plaintiff being a business, it was also on behalf of me as an individual, in which case I represented myself.
What? So she represented herself as an business entity. What? That's no. What? I'm not good at math. Here's the thing. What he is saying, you filed this pro se as in you represented yourself.
Yes.
And you did 3 times over. You represented yourself, you as the owner of the business and the business itself. Yeah, but that's still you representing yourself. You are representing yourself pro se.
Yes, that makes sense. She's not the Trinity manifested. You cannot be the Father, the Son, and the Holy Spirit at the same time. I don't believe you're qualified.
Oh.
Right.
Initially.
Right. Initially, no other lawyers were involved when that complaint was made, right?
Initially, they became involved after.
Okay. And you.
What the fuck happened in the middle of the screen?
He's putting on his handy capable sticker. Of all the things you could possibly do off screen, sir. Like, just.
And this is what I didn't see because I was using my phone and just listening, and I only saw the judge, Shockett, and Voldemort. I didn't see other things that were going on. So this is new to me.
Okay, so is just this man has no purpose being on this stream other than he is one of her minions / cohorts.
He's another person that inserted himself into something that had nothing to do with him.
I feel like we're watching a completely different movie. Like there's like five of these screens are on the trial, and then one of them is watching an Ernest movie.
He's the one
unaware of.
He's the one that called Jeremy Hales an alligator fucker.
Sir, the Dom DeLuise should not
in a legal document. In a legal document, not like on a stream.
Well,
but in a legal document. He comes in my chat all the time. He was in my chat today.
Well,
sir,
kudos to Mr. Hales, because if you can pull that off, that's impressive.
Yeah. Also, sir, you look like the living embodiment of Dom DeLuise. Perhaps one should not make, statements of a derogatory nature towards other people when they're not living in, the most solid of houses.
Yeah. And apparently, his name is Richard, right?
Yeah, also known as Paint Chips, because I think it was Shizzy who gave him the name Paint Chips, because he must have ate paint chips as a kid.
Yeah, so Dick down there has spent 2 years in federal prison and is disbarred.
Yeah.
So that's the handicap.
Goes to law school. Oh my God.
All right.
You were involved in that litigation from March 2021 through October 2022, right?
If that's the dates, I don't have them in front of me, so I would assume so.
That case involved extensive litigation activity, including discovery requests for admissions, motions to compel, and multiple hearings, correct?
There was only one hearing.
Okay. And there was a voluntary dismissal entered in that case, that you and only you signed, correct?
Well, Andrew Probst was co-counsel, and he was still on the case as co-counsel. So when I voluntarily dismissed it, I signed my name as Leslie Ann Law, and he was still counsel of record as well as co-counsel. So
was that before or after you retired? Because if that was signed in, what was it, in 2022, when was she disbarred? What's her last name? No, don't say it out loud.
I'll put it in private chat.
I feel like that's a trick question, Nick.
It's in private chat.
Well, she wasn't disbarred, but when she retired,
it was retire or face consequences.
Yeah,
kind of an even though technically it wasn't stated that way, they dropped the case as moot because she permanently retired. But if she had stayed in, there was a 99% chance that there was going to be some sort of disciplinary action. Possibly up to disbarment. But she has threatened to sue people over saying that she was either or. And I don't agree with her logic. However, I see the legal loophole that she's using to, well, they didn't actually say that. No, it's not in any documents that I could find that says one or the other. But it's kind of like that cop. Like you retire or you get fired.
She was permanently retired around September, October 2021. So when she signed that as head counsel, she was practicing law. That's interesting. If you sign that in 2022 and refers to that other person as her co-counsel, she's admitting to practicing law.
Yeah,
despite being forcibly retired.
Now, is she even allowed to do what she is tangentially doing? Because I would think that there would be some kind of, keeping her out of it. It seems kind of odd that she had to relinquish her, license or her ability to practice, but can still work in a paralegal function for her husband's practice.
Yes, sadly, the distinction is quite clear. Practicing law as an attorney, you have to be admitted through the bar. She's not practicing law as an attorney. She's doing pro se as herself as a private citizen, and being a helper for her husband is not, well, it can be considered, but it rarely happens. But this here, under oath, that can be used because she has just admitted she signed that as a head counsel at the time when she was permanently retired.
She has also admitted certain things that I really wish I could. You know when you want to say something but you can't. She's basically admitted to what she's accused other people of doing.
Yeah.
To my lawyer.
Yeah.
I was not the only person on that case. He had never withdrawn from the case at that point.
You were the only one that signed the dismissal, correct?
Correct, but there was another attorney on the case as well.
All right. And given that you dismissed this case in October 2022 and more than 2 years now have elapsed, you cannot refile that action now, correct?
There was other claims. I would have to look at the statute of limitations to see, but I don't intend to refile it as I don't want to move forward with that case. There's a lot to that case.
All right, let's talk about another defamation action. On December 20th, 2023, you filed pro se a complaint for libel and slander against Kayla Federigos, Paul Russo, Nicholas Federigos, Kathleen Bors, Danny Federigos and Eleni Federigos, correct?
Correct.
And some of these people
Kathleen
are
and
related
Danny
to you,
were there.
Okay.
correct?
Correct.
Including Kathleen Bors is your mother, correct?
Correct.
All right. The court dismissed that case on August 22nd, 2024. Isn't that true?
They dismissed it without prejudice for failure to timely be able to serve within 120 days. After that, my husband, who is an attorney, mediated with his family members, and we decided to not pursue it after the court dismissed it without prejudice, leaving it open for me to file it again should I want, but it was mediated and settled with a family member, so we did not pursue. I did not move forward with refiling.
Right. The reason why the court dismissed the case that you filed pro se was because you had not perfected service on the defendants within 120 days of filing, right?
I couldn't.
She couldn't serve her family members within 4 months.
And the interesting part about it that raised an eyebrow for me is on any of these cases where she couldn't perfect service, there is nothing that she ever filed that said, I need an extension, this person's evading service, I can't, whatever reason that people can't perfect service.
Yeah.
I
mean, if you use a process server, you get the paperwork. I tried, couldn't.
In one of my notebooks, I literally went through and wrote down her cases and wrote what it was, the date it was filed, and why it was dismissed. We've gotten. She hates me. She hates me.
But to my understanding, she hasn't. There's no filing with the court in this particular case where she actually made attempts to serve.
Nope. Nothing.
Get all of them serve now.
All right, let's talk about a 2024 domestic violence injunction case. You mentioned Michael Federigos, and who is your husband and your lawyer in some cases, right?
Correct.
Okay. On July 23rd, 2024, you filed pro se a petition for injunction for protection against domestic violence against Michael Federigos, correct?
Correct.
Now, remember, in Florida, a stalking injunction like that, or a petition for injunction for protection against domestic violence, requires you to state under oath that you have a reasonable fear of imminent harm, right?
Correct.
Okay. And you did so in that case. You signed a petition under penalty of perjury in that case, right?
Correct.
And you voluntarily dismissed that case before a hearing again, right?
I settled with my husband, who agreed to go to treatment. We signed, he is if you actually had the documents to the cases, not just the titles, you would have seen, I dismissed the case after he agreed to attend treatment.
In a 911 call.
The court entered an order.
That's a lie.
Dismissing the injunction.
In a 911 call, she says, Michael Federigos refuses to go to therapy. And also, that was from another person who posted the rebuttals of things on a Facebook page. But also, in their bankruptcy, both of them Michael filed bankruptcy as well. That's what she tried to sue me for, is that I did a bankruptcy stream where I read his documents, but I used their name, and she was trying to, play stupid. But he says in 2024, when that was going on, that they never lived in the same house. And also, someone brought up a good point earlier. If you have a order of protection against someone, how can you talk to them and find out if they agreed to go to therapy?
Interesting. Yeah.
That I didn't even think about.
There a hearing on August 1st, 2024, right?
There was never a hearing. There was never a hearing in that case. It got granted ex parte. Prior to going to a hearing, my husband and I worked this out where he promised to attend treatment. That was when I voluntarily dismissed the case. We never had a hearing on that case, and the court adopted the voluntary dismissal.
Right. So you didn't want to maintain the protection because you said you had a reasonable fear of imminent harm simply because he agreed to go to therapy. Is that what you're saying?
He agreed to do a therapy program, and we were not living together at that time.
Okay. So A year later, on March 3rd, 2025, you filed another pro se petition for injunction for protection against domestic violence against Michael Federigos, right?
Correct.
And the same thing applies. You swore under penalty of perjury that you had a reasonable fear of imminent harm again, right?
Correct.
Yet, the very next day, you voluntarily dismissed the case, right?
I did.
And you stated in your response to request for admissions in this case that the temporary order was granted but settled prior to a permanent injunction, right?
Correct.
All right. Can you tell the court in that case how you can settle a case like that when the very day before you swore under oath, under penalty of perjury, that you were in fear of imminent harm?
Because we decided to go to a church. And we thought we do not like the court. We do not like being wrapped up in court. Ironically, as you were trying to say, I'd like to flee away from the court. It was a family matter, and we decided to take it up in church. We thought that was the better route. We had an extensive discussion, and I voluntarily dismissed it.
Okay. I just want to make sure to get this clear. So within a year, you filed pro se 2 domestic violence injunction petitions against your husband, obtained temporary orders, and then voluntarily dismissed both cases before any permanent relief was granted, right?
Before any hearing or permanent relief, correct.
All right. Let's 2 more cases to talk about here. Let's talk about the guardianship appeal for the second DCA. You were the attorney of record in this guardianship matter in which you represented the mother of a ward, correct?
Correct.
And you as the attorney received sanctions in that case, correct?
My client and I both did, correct.
Both you and your client were sanctioned, right?
Correct.
And you filed pro se an appeal to the Second District Court of Appeals.
I did.
As the appellant pro se, right?
I appealed the sanctions against me personally as the attorney on the case.
And the second DC, that were case number 2D23-424, correct?
It was a 2019 case. The state case, the guardianship case, was filed in 2019 by the ward's mother. I came on to the case later. I represented the ward. It was a discovery issue that we got sanctioned on, and I chose to appeal because at that time I ended up leaving the case. I was no longer representing the mother anymore, but the sanctions.
I believe that is the case where she didn't tell her client there was a hearing, so the client got fined. And it was one of the bases for her bar complaint, if I remember correctly.
I think that's it. There's some people in chat who know that one way better than me. They're all starting to run together, to be honest.
Yeah, I mean, sooner or later, with this amount of cases, and probably more in the pipeline. But I mean, the only thing I covered around this person is the bar complaint, and those are just the one who went to a bar complaint.
I stayed close to documents. I never did like personal attacks because I knew she was litigious. So when I told my lawyer, he's like, what do you talk about? And I was like, I give my opinion on her legal documents and her legal cases and what I think about her filing these legal documents. Public record.
Yeah, my jurisdiction is across the pond.
Mary Beth brought up a really good point in chat that I completely forgot about. When she called the cops about her internet, she told Neil.
Yeah, I remember that. I listened in on that call. Well, I didn't listen on that call, but I think you covered it and I listened to it.
I think that was Megan.
Oh, maybe it was Megan.
They do a lot more of the 911 calls. I literally just do documents. That's the only thing I'm good at. She's good at. Megan's the FOIA queen.
Now, is she just, again, what does she get out of this family wise?
Devil's advocate. And see, that's the thing. I try to play devil's advocate because I try to see both sides of things. She has admitted to being bipolar. So there are times when I believe personal opinion, she gets in a mania and a manic episode where she just does things.
But the common motto of being an adult is that whatever you're carrying, you don't allow it to, go out and hurt other people.
I'm not gonna lie.
My heart goes out to her if she is dealing with, bipolar. It's hard to diagnose, it's hard to treat, and it's hard to, be consistent with treatments and medication. So I get that. But what does she get other than people, stop talking about her, and then she ends up losing her license? I just do not get what she is attempting to achieve by doing any of this.
I'm not sure, but the only, well, not maybe the only, but it's how she treated her clients. I mean, she was fresh off the bar in 2017, and by 2019, 3 years later, she started screwing clients over.
The funny thing is she graduated from college in 2015.
She went through law school in 2 years.
She
Really?
She graduated in 2015 because she graduated the same year as my lawyer, and she didn't pass the bar until 2017.
Oh, okay, that's a sequence. When you say college,
well, she graduated law school. Sorry,
graduated law. Yeah, we have a few more instances before we can go. We have to have a college degree, then we go to law school.
Yeah, the tier 2 is.
Yeah, but regardless, 2017 and 2019, she started screwing her clients over.
No,
and then
correct me
eventually got retired in 2021.
Weren't most of her clients, again, kind of trying to piece this together, weren't most of her clients like people who needed guardianships and things like that?
Yeah, family law.
That makes it even worse. I mean, because I can see, being time blind or making a mistake and it costing a corporation, and that's a screw up that you have to take ownership of.
Yeah.
But when you're messing with people's family, that's a whole other level of ick.
Yeah. I went back for because there's some articles and some videos of her 2017, 2018, 2019. She was a big men's rights. She was big on that, but I can't find that she actually represented those cases.
Oh.
So I'm not entirely sure what she was doing online when she was in family court. She was predominantly representing mothers. So, and fuck them over. So maybe that was part of her plan. I don't know. Yeah, let's go.
Were still against me as well as her. So I represented myself in appealing the decision against me.
Right, but the appeal had a 2023 case number, right?
It was attached. The whole case started in 2019.
The appeal didn't
It was
start.
an appeal from it. The appeal was 2023, but the case that it stemmed from is 2019.
Thank you. And the second, you lost that appeal, right? The second issue.
I did lose that appeal. Yes, I did.
All right. And that appellate decision was a final and adverse determination against you. Isn't that true?
Correct.
All right. Let's talk about the federal case you filed. On February 2nd, 2023, you filed pro se a civil action in the United States District Court for the Middle District of Florida against the Florida bar, correct?
Correct.
You were the plaintiff in that, correct?
Yes, I was.
You represented yourself in that case, correct?
I did.
And in that case, you filed pro se, an original complaint, then an amended complaint, then a motion to amend, then a second amended complaint, all within the opening days of the case, correct?
I would have to see that. I don't recall that. I know that case, because I retired my license, they dismissed the case as I no longer had standing to pursue that case because I no longer was an attorney. I'd retired my license. When I filed that case, I was an attorney. When I retired my license, that case was still pending. and the court dismissed it on the grounds that I no longer had standing because I no longer was an active lawyer. And so, however that went, I don't know. I would have to look at the case before I could answer those questions with definitive answers for you. But I can tell you that was the initial reason that case got dismissed, was for lack of standing when my status changed.
So I want to make sure we get an answer here. You'd have to see the docket sheet to be able to answer the question that you filed pro se, all within the opening days of the case, an original complaint, then an amended complaint, then a motion to amend after you filed the amended complaint, and then a second amended complaint. You would need to see the docket from the federal court.
Yeah, I'm sure if I did, it happened in the beginning. However I amended, I exercised my right to be able to amend, just like any
Bless your heart, princess.
in cases, they have to amend things when newly discovered evidence happens, things like that. It gets amended, and that's more than likely why I amended it. But regardless, the case was dismissed because of my status changing.
Right,
He is not talking about the case being dismissed, genius. He is talking about the case. There's multiple ways to be labeled vexatious, and part of it is food.
Yeah,
Jesus.
part of it is filing unnecessary. And Joseph DiMartino, as an attorney, you should know better than to represent yourself. Remember, when Clarence Darrow, possibly the greatest American lawyer of the 20th century, was accused of jury tampering, he hired a lawyer. Yeah. And speaking of that, let's see if I can find it quickly. I did that. Let's see if I can find it quickly here. Dun, dun, dun. Where did it go?
It's like, oh. But she's also filed a motion to get Jeremy Hills labeled a vexatious litigant. And you don't have to like Jeremy Hills at all. However, the definition of a vexatious litigant is pro se. Jeremy Hales has always had a lawyer. Love him or hate him does not matter. Definitions matter.
Yeah.
And that's one of the other reasons it's always important to have a lawyer.
Yeah. And I did this grok, which famous person does my tweets remind you of? And I got this answer. Clarence Darrow saying, veteran labor lawyer, ta-da, exactly like my 30 plus years, who then pivoted into high profile public cases and became a sharp no BS commentator on the justice system's failures. You dig into the weeds of evidence, procedural screw-ups, hired gun experts, missing texts, and procedural shortcuts the same way he did, calling out horse shit without soft pedaling it. So I'm happy. If I'm compared, if I'm ever that successful, I'll be happy. I will be happy. And, I knew of him before Grok reminded me, because he's an absolute legend, and he has, in a matter of, I believe it was in a matter of just a couple of years, he had 2 cases.
I'll be right back.
Who are still case law.
Oh, wow.
To trials that are still regarded as a shift in American justice system. Yeah.
Wow.
Now, I will not go into private practice anytime soon. But if I ever do, I have no idea if I ever get a hold of those cases. I doubt it, but it's nice. It's nice to be compared with him. I mean, after close to 35 years, I mean, I've represented thousands. And not as a lawyer, but as a mediator, negotiator, and just local representation for workers. And I have to say, I am quite successful. I mean, everything from protecting one person's job to the bigger cases. My biggest case were where an entire workplace went down, and I negotiated for 150 employees. I negotiated a $20 million settlement. I'm quite happy. except that I'm salaried and didn't get a percentage. So, yeah, I think I'm doing good. I'm actually I'm actually really fucking good at what I do. That's what I meant to say. All right, let's continue.
Important recommendation recommending dismissal of your Second Amendment complaint for lack of subject matter jurisdiction on mootness grounds, right?
It was moot when I retired my license.
Right.
That was what you'd have to read the whole order, but that was, from what I recall, that was the big reason, was because my status during litigation had changed from an active attorney to a retired attorney. Therefore, it was moot and it was no longer an issue.
Well, that's interesting because after the case was closed as being moot, you filed pro se motions to vacate, motions to disqualify the magistrate judge, and motions for reconsideration, correct?
Correct.
And all
Yeah,
of those,
the magistrate-
all of those post dismissal motions were denied, correct?
Correct. Yeah.
The case terminated August 21st, 2023, right?
It did, but everything I did was in good faith, and there's always legal grounds to everything. Should you be inclined to give the court the actual filings and not just the titles in a docket, there's nothing that I have ever filed that has not been backed up by law. No court in any of these cases have ever found me to be frivolous, bad faith litigation.
That's what this hearing is about, declaring you a vexatious litigant, because even though the individual cases where the bar is higher, the combined amount of cases gets you there.
No one ever looked before or asked. Genius. Oh,
Yeah.
It gets more ridiculous from here. But this girl wouldn't know good faith if it smacked her in the face.
Yeah. And the reason that case went moot was that she voluntarily retired.
Well, and
so
I guess
she made it moot.
Yeah, I guess that's where I'm having a hard time following, because the way she's kind of narrating this, as someone who doesn't know the facts like you do, again, I know because I trust you guys that she is, a bad faith actor, but she doesn't seem to be aware that I mean, I've tangentially watched and looked at some of her documentation. It doesn't follow any form that I've seen in 4 years. And I say that as someone who is, transparently not a lawyer, but hers don't make sense even like foundationally with grammar.
Yeah. This is like, say in trial, the saying is you can't open your own door to evidence. You can't ask the witness a question and then say, hey, judge, now you can let my evidence in. No, the other party is the only one who can open the door. She is trying to open her own door.
If she gets labeled a vexatious litigant, I'm reading all her emails on a stream.
Yeah. So she's she's trying to claim to the judge that the only reason why this was moot was because my change in status. Yeah, but you changed your status. It was either that or getting punished by the bar. And you chose. Instead, because she could have, she probably would have kept her bar card. She might have gotten 6 months, you can practice law or something, or even high fines, but she could still, after that, practice law. She took the option of, instead of being punished, to simply retire.
Well, she seems to think that filing frivolous lawsuits is the only way to be labeled a vexatious litigant. No. Malicious prosecution. Multiple things, like even after she retired, she filed for whatever, I can't remember,
reconsideration and all
the shit that had already been decided and was not just extra drama that she did not need to be causing. And it's like she seems to think that the amount of frivolous quote unquote lawsuits is the only way. It's like, no, that's only one. And these lawsuits that he's bringing up are not just for frivolous. It's unnecessary. Unnecessary things that are already been decided. Like repeated relitigates things that already been decided. Like it's peppering the court. Like the 3 different complaints within a week or 8 days, I think it was. It's like, holy crap. Can you tell I don't like this woman? Is it that obvious?
Yeah.
Oh, but I got a book sent to me the other day that I'm going to start reading.
By the way, on the YouTube chat, I started a goal because I want to spin the wheel of regrets.
And y'all need to send super chats because how Nick is making it through this sober, y'all need to do a better job. This is slightly buzzed and he's sober as hell. I'm more drunk than he is. Look at this. When have you ever seen me open and almost empty an entire bottle of wine?
Yeah.
Y'all need to fix yourselves.
Yeah. So I put the goal at 15 supers at $2 or more, and it's a spin on the wheel. But I do calculate it as the total amount of sum, which is currently, since these are half shots, is just $25 each. So and these are the one remaining, 4 of them. Apple pie, glitter whisk, sour S, and coffee.
Oh, and Nick, I sent you a Twitter DM that is appropriate for when she starts her case. It's appropriate for something she says that she accuses Jeremy of. And I say this as someone who's not actually a Jeremy Hales fan. I don't subscribe to him. I don't watch anything he does. I'm just interested in this case because it's interesting. I want to know if courts will start taking online issues more seriously instead of just going, it's just the internet. It's just the internet. It's the court version of a doctor saying, it's just anxiety.
All right, and here we go. Thank you. Okay, the cat lady, $2. Thank you so much. And on them, $5. Thank you so much. Thank you so much. Thank you. We're on the way. All right, let's continue.
I have never been found to do duplicative filings on things that have already been decided. Anything I did, it would be no different than I was exercising my rights under good faith.
All right. Let's look at your history. You have fought at least 8 separate actions between 2019 and 2025, correct?
Correct.
All right.
Well, I would say
not counting the
season. The one case
letters.
Started, but yes, there was 8. There was it's in my response 4 injunctions, 3 civil cases, and the appeal from the guardianship case. Now, you never mentioned in your amended motion about
motion
lawsuit, so I never knew that was coming in until
motion. Woo. And how Megan is keeping a straight face, I don't freaking know. I'd have to turn off my camera at this point. God bless her.
Just now, because that was never pled in your amended complaint that's before this court today.
All right, let the record reflect that it was in my memorandum in reply. So in all of these 8 cases, you obtained...
And
he just lets her speak and then, let the record reflect.
Just a word about this judge. She is a former DOJ public defender.
Oh.
And her husband is a retired Orange County deputy.
Oh.
So she's not one to be.
Yeah.
One of my friends is friends with her husband.
Oh.
Well, I don't know if they're friends, but they're acquaintances. But I've been told she is not one to. She's one that you want on her side until she's not on your side. When she's not on your side anymore, she's not on your side.
Yeah.
Absolutely no permanent relief or favorable final judgment, right?
I never had any adverse rulings except for one in an injunction case, and the other two were never decided on the merits. They were the two that were actually ruled on by the court was for lack of being able to serve somebody in time, and the other one was for lack of standing. But at no given point has any court ever found or dismissed anything on the merits of any of my complaints except for the one injunction case. That was it.
Let's try one more time. I didn't hear an answer. So in all 8 cases, you obtained absolutely no permanent relief or no favorable final judgment, correct? Yes or no?
I'm not, it's not really a yes or no, because there was no adversarial determination except for one. I could have easily, no, I mean, if I wanted to go back and I wanted to refile the civil case that was dismissed for lack of service, I could have done so. So I wouldn't consider that as, I couldn't, that was a permanent stop for me to do anything. I chose not to, but at no point did I ever have anything dismissed with prejudice or have a court tell me that I lacked merit in anything that I've ever filed. I've never been told that I was frivolous. I've never been deemed to be bad faith. I've never had any court, that was under the jurisdiction of these cases, ever find me in any of those capacities. So if I wanted to refile something, I could. I was never stopped from that. I was never limited.
So I only have a couple minutes left, so I'm going to go more quickly here. So you, as a former attorney, you are familiar with Florida's vexatious litigation law, correct?
Well, the actions that have taken place when I was on notice was the original vexatious litigation law 68.093. It only got amended in July after the actions that I took part in. So I was very familiar with the original during the times of those actions. But no, I would have never anticipated having to, I was never placed on notice that injunctions for my protection would deem me a vexatious litigant when I chose to file those. So
this shows intent. She knew about the vexatious litigation law up until it was amended. Had she known, she would not have used that tactics. That is an admission.
It is almost like she knew about it. She skirted the law. You know, when someone like wants to do something wrong, but they're like, I'm not touching you. I'm not touching you. But they're like just there, but they're not doing anything wrong according to the law. That's what I feel like she did.
I was operating under the original when every single action I've ever filed was under the original statute that I was noticed on.
All right. And you are aware that the 2025 amendment expanded the definition of action, quote unquote, to include now family law matters, right?
I'm aware that it's very substantively changed. And it has not only expanded what is called an action, but it's also expanded the look back time. It's also given more sanctions available to a court. It has also changed the definition of what pro se means during litigation or during an action. So it has greatly substantially changed the new amended one. But when my actions took place, that wasn't in effect. I was under notice of the original statute.
All right. You understand that filing a lawsuit with the intention of withdrawing it before prosecution in order to create a public record does not constitute filing in good faith, right?
I would say what you showed the court is not complete, and it is not authenticated. It is not dated. So to operate under.
Yeah, she doesn't claim it's not her. It's just, oh, it's not authenticated. Oh, it's not dated, but it's you. It's still you. A horrible, bad goth version of you, but it's still you.
The fact that those are my words outside of court would be, it wasn't even authenticated, dated, or it doesn't even explain to what I'm even talking about. Wasn't complete as well. But no, yes, of course, when you file, everything gets put on the record, but that's not the only reason you file. I filed everything I did with good faith. I have affidavits that in the one of the lawsuits that you had mentioned, I have affidavits from 3 different people that were filed as well with that complaint. I don't file frivolous frivolous complaints where I don't have evidence before I file those. So no, I don't just file things to be put on the record. It's a given they'll be on the record, but that's
Then
not
why
the
did you say
motivation
that?
why I have filed my lawsuits.
Yeah.
Then why did you say that? That's what you said.
Yeah.
We can only trust the words that come out of your mouth.
Yeah. And she's more than welcome to play that entire interview for the judge if she wants to.
And you guys, I have to pop out. I got to get ready for Shizzy, and 6 children does not a strong bladder make. So restroom break before new stream.
I don't know how you do it 6. With 1, I'm already like.
I don't go on trampolines anymore.
Mo, we have a trampoline right there. Mo, the little starts pre-K on Monday. Wish me luck.
Good luck, and it's okay to be a little sad and a little excited to have some quiet time.
Oh, and with the case I mentioned to you in chat, I have the appeal. If you want a case where you can rage out, I might do a Rumble only stream about the appeal, and I have the notes from the investigators.
Awesome. So, that would be fun. I am, after the Clancy case, probably going to take a break and maybe talk a bit more about masking and some other things that, just random stuff in body cams, do a little reset.
There's some good Tony Romo DUI footage. So there's
awesome. Well, thank you guys for having me on. Thank you, Nick, and good to see you, Squid. I will see you guys in a little bit at Nick's, or not Nick's, Shizzy's. That other place that I am.
Yeah.
Tell Shizzy I said hi.
Yeah, I will be redirecting to Shizzy. No, Shizzy. After this.
I'm the one who's drinking, and y'all can't pronounce Shizzy.
Nope. Bye, you guys.
Bye.
See ya. Wine gone.
Oh. Yay, slightly buzzed. This
is either going to take my headache away or make it worse.
Yep.
So again, there's no answer here. This is important. You understand that filing a lawsuit with the intention of withdrawing it before prosecution in order to create a public record, that does not constitute filing in good faith, correct?
I wouldn't know that because that's not anything I did. And I don't know. I know what good faith is. I know the definition of good faith. And I'm prepared.
It's the definition, not the
evidence that everything I did was.
He just told you the definition.
Well, she knows the definition. She doesn't know the actual practice.
Yeah.
There's a difference.
Filed in good faith. And if you gave the judge the opportunity to read through all the pleadings of every one of my cases, not just the titles, you could see very clearly I never filed anything that was not in good faith and was not supported by the law, nor has any court who had jurisdiction over those cases ever found such.
All right, 2 more questions. I'm going to turn it over to Ms. Federigos, Your Honor.
Bless Megan's heart.
Understand that if you are declared
how she's doing this, I don't know.
You may be required to obtain leave of court before filing new pro se actions. Do you know that?
I have seen that now. Yes, I've seen all of the new sanctions that they have now broadened the statute. I've read it extensively. I've also read the discussion with the House on this bill. I'm very familiar with this bill, and I'm very familiar with the substantive changes that have taken place with the amendment.
All right, if you're very familiar, then you obviously understand that you may be required to post security to cover the opposing party's litigation expenses, right?
Security would be if I actually filed this lawsuit against you. You filed this lawsuit against me. And for the judge to determine whether or not I needed to post security, would not only the judge would have to find me vexatious under my past actions that a different statute was operating under, when there's been no final and adverse ruling from a court, but the judge would also have to look at my filing against you. Should I file against you a lawsuit? And they would have to determine whether or not I would succeed on those grounds. It is not right to ask for a security when I'm the defendant in this case, and I have not filed a lawsuit against you at this date.
You do know that the 2025 amendment changed that to make it available. The post-suit security covers an opposing party's litigation expenses, whether or not they're a plaintiff or a defendant. Have you understood that? The 2025
No, I have not understood it like that. I've understood it that a security is there should I file something on you, and the court would have to determine whether I had merits because you have sued me. I am a defendant not wanting to be involved in this. And I'm.
It doesn't matter if you want to be involved in this or not. And the judge is so sick of her.
The judge is like, I'm done. Like, what are we doing here? But what is the phrase? When the facts aren't on your side, attack the statute. When the statute isn't on your side, pound the table.
Yeah, but she's pounding herself. I mean, she's not doing herself any favors by being avoiding. She's pro se here as well. She is regarded at the same level as an attorney, and she used to be an attorney. Means that like the judge regards. Okay, for fuck's sake.
I feel like that's a legal loophole. Is people who used to be attorneys who are representing themselves pro se. That's like some legal loophole because pro se defendants are treated differently because they're not attorneys.
Yeah.
And it's like, well, not attorneys. Like I have a friend who's a retired law enforcement officer, but he went to law school. I regard him as a little bit more educated and a little bit different than a cop, than a beat cop, because he went to law school.
I want to go back and
thank you.
When she says I didn't say the things I said,
and I still don't know how Megan is
complaints where I don't.
She's sitting here.
Where was it?
Means during litigation or
where was it?
With the original during the times of those actions, but no, I would. But at no given point has any court ever found or dismissed anything on the merits of any of my complaints except for the one injunction.
Final judgment, correct? Yes or no?
I'm not. What I'm gonna. It's not really a yes. I wanted to refile the civil case.
Where is it?
It was not to, but at no point was I ever. Did I be bad faith? I've never had into court any limited.
So I only have a couple minutes left, so I'm going to go more quickly here. So you, as a former attorney, you are familiar with Florida's vexatious litigation law, correct?
Well, the actions that have taken place when I was on notice was the original vexatious litigation law 68.093. It only got amended in July after the actions that I took part in. So I was.
Where is it?
For my protection.
I know it's somewhere around here, or should be. Was it that far back? There it is.
See very clearly, I never filed anything that was not in good faith and was not supported by the law, nor has any court who had jurisdiction over those cases ever found such.
Having received her cease and desist and the 10-page document, if she is labeled a vexatious litigant, I will send you the proposed, because she not only emailed me the cease and desist, when I didn't respond to any of her emails, I just forwarded them to my lawyer. She kept emailing me and emailing me and emailing me. She sent me like 5 emails to the point where even Mr. Squid, who is usually like, let it go, don't worry about anything, why do you care, was like, sue this bitch. Counter sue. If she doesn't sue you, sue her. And I'm like, well, that's a little much. But
yeah.
But she sent me the 10-page-ish lawsuit that she was going to file against me. Now she moved it to when she countersues Jeremy, Megan, and Tug, she's adding me to that lawsuit. So like, as much as I don't like Jeremy and I don't really watch anybody involved in this shit, I have a vested stake in this because if she gets labeled a vexatious litigant, I don't have to worry about spending money when shit shouldn't be spent. Kind of a situation. So,
and Dave puts us over the $25. So here's the next one. Dun, 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 dun. Next one is sour S. Now, sour S over here in Sweden is a really, really sour candy. And now, when I say it's really sour, you get blisters on your tongue by sour S. So this will be interesting. Here it is, sour S. Dun, 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 dun. Here is my Utah shot glass. Dun, 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 dun. And since this is only half a shot, hence the $25. But cheers!
My hair is like...
Oh, that's sour.
That looked really yummy.
I mean, it's amazing once you get over that initial hurdle. Hurdle.
Big pucker factor. I think, speaking of pucker factor, Bruce from Wisconsin made a comment earlier that was like something about, oh shoot, what did he say? Where is his comment? Dude, I freaking saw it. It was like, it was talking about what a Friday and like, people, effing themselves on a Friday. I'm like, oh, you know, that's
Jeff's Fuck It Fridays.
yeah, pounding herself. Well, it's Friday.
Oh, yeah. Thank God it's
Okay.
Friday.
Hi, Bruce.
Hi, Bruce. Oh. Dun, dun, dun.
Questions, I'm going to turn it over to Ms. Federigos, Your Honor. Ms. Federigos, you understand that if you are declared a vexatious litigant, you may be required to obtain leave of court before filing new pro se actions. Do you know that?
I have seen that now. Yes, I've seen all of the new sanctions that they have now broadened the statute. I've read it extensively. I've also read the discussion with the House on this bill. I'm very familiar with this bill, and I'm very familiar with the substantive changes that have taken place with the amendment.
All right, if you're very familiar, then you obviously understand that you may be required to post security to cover the opposing party's litigation expenses, right?
Security would be if I actually filed this lawsuit against you. You filed this lawsuit against me. And for the judge to determine whether or not I needed to post security, it would not only the judge would have to find me vexatious under my...
Yeah, no. Vexatious means you have to put up the money regardless. Because, yeah, it might be a bitch that you as a defendant have to put up the cost of the plaintiff's or security for the plaintiff's costs. But stop filing shit lawsuits.
Song of Rain said, did I miss the part where Randy mentioned she sued her own mother? Yeah, her mother was actually observing this hearing along with her brother-in-law.
No, $25 is a half shot, Dave. Yeah, there were money in there before you, Dave. So $50 is a full shot, 25 is a half shot. This is a full shot. So, but Dave, you know now you decide my poison. What do I have over here? I have whiskeys. I have Finnish whiskey. I have Scottish whiskey. I have salt licorice vodka. I have bourbon. I have Old Smoky. I have tequila. I have vodka. I have schnapps.
Finnish whiskey. Oh, no, sorry, Dave. My bad.
So it's up to Dave. It's up to Dave. I don't mind Finnish whiskey. It's
sorry.
It's good law.
Is there any good Finnish whiskey?
Yeah, this is good.
Because I was going to buy something for my grandpa's birthday this year.
Yeah.
Just as like a toast to him, and I didn't know what to get.
It's sherry matured single malt whiskey at 50.7%. And over here, it's around $60. Don't know what it would cost you to get it to the States. The strongest stuff that you have is me. I actually think the Kulo is the strongest at 50.7. The strongest I used to have is Navy Strength Yin. I believe that was at 57%.
Well, I feel like that's insulting or a compliment. I'm not sure.
So that would be a full shot.
Cynthia,
I will take it in my bucket.
Cynthia, you and my dad are the same. 7 and 7.
All right. Thank you, Dave. Cheers. Oh.
Hey, Bruce,
Nom,
how
nom.
much would it take to get you to send me some oh crap, now I can't even remember the name of it.
Cool.
The stuff that can only Spotted Cow.
The what?
Spotted Cow. It's a beer that can only be sold in Wisconsin. And if you sell it outside the state of Wisconsin, you can get fined. You can buy it and take it other places. Like
I will be in Indiana in September, so I can drive up to Wisconsin.
Navy. Oh, Roy. You can't send it. You have to carry it out of Wisconsin. Yes.
Oh.
Roy said Navy strength, so incredibly weak, right, Squid? Oh. Just climb back in your tank, button it up, and take a deep breath.
Oh. I wonder if I might still have the bottle. Maybe.
Cynthia, my dad has drank 7 and 7 since before I was born. Like that's his thing. 7 and 7. No matter what, 7 and 7.
Yes, here it is. This is the bottle of Navy Strength. Oh, I actually have some. I didn't know I still have some.
Navy Strength.
Yeah.
You know what it looks like? It looks
50,
like it looks like paint thinner.
Yeah.
Probably smells like it too.
57.1%. That grows hair on your toes.
Ooh, back 40 amber. Bruce, I think I'm just in the I want what I can't have. That's what it is.
All right, and I also, the way Meg is holding back must absolutely.
Dude, I don't know how if she's on that phone, she's taking notes, but I'm pretty sure she's texting Tug like, what the fuck is this? I don't know. I would be, because Tug was there too, obviously being a party to the case, but there was a couple other people who were there, and I'm pretty sure Shizzy was there too, and I'm pretty sure she was probably texting Shizzy like, are you seeing what I'm seeing? Like there was a cast of characters there. Even our good friend, even everybody's favorite being punished right now lawyer was there. Rackets was there.
Yeah.
So
no, yeah. But folks, look at the judge here. I mean, her expressions. I mean, she has a good poker face, but not that good.
It was not supported by the law, nor has any court who had jurisdiction over those cases ever found such.
All right, 2 more questions. I'm going to turn it over to Ms. Federigos, Your Honor. Ms. Federigos, you understand that if you are declared a vexatious litigant, you may be required to obtain leave of court before filing new pro se actions. Do you know that?
I have seen that now. Yes, I've seen all of the new sanctions that they have now broadened the statute. I've read it extensively. I've also read the discussion with the House on this bill. I'm very familiar with this bill, and I'm very familiar with the substantive changes that have taken place with the.
Yes, you are, because you, as Squid just said, scouring the lines. All of a sudden, she's way over the line with her actions. And that is her admitting to the judge, yeah, I am a vexatious litigant. I'm just trying not to be caught.
The amendment.
All right, if you're very familiar, then you obviously understand that you may be required to post security to cover the opposing party's litigation expenses, right?
Security would be if I actually filed this lawsuit against you. You filed this lawsuit against me. And for the judge to determine whether or not I needed to post security, it would not only the judge would have to find me vexatious under my past actions that a different statute was operating under, when there's been no final and adverse ruling from a court, but the judge would also have to look at my filing against you, should I file against you a lawsuit, and they would have to determine whether or not I would succeed on those grounds. It is not right to ask for a security when I am the defendant in this case, and I have not filed a lawsuit against you at this date.
And Nick, I have a question
know that the
for you.
2025 amendment.
Sorry, what you say?
I have a question for you. So she keeps claiming that the statute can't be applied to her because it was in July of 2025 and all of July 1st of 2025 and all of her actions were before that. I'm going to share my screen with you.
It depends on how the new is applied, if it's applied retroactively or not.
This is the actual statute from the Florida legislature.
No.
And section C, paragraph 1, it says in the immediately preceding 7-year period.
Section C, a person is defined proceeding per se who in the immediate preceding 7-year period. Okay.
And
that is in wording being retroactively from the date of when this law came in place.
July 1st, 2025.
Yeah, so 7 years prior. That is my reading of it.
That's what I thought too, but once again, not a lawyer, so I always
it still needs a precedent for it.
Oh, speaking of precedent, I have a vexatious litigant list as of July 23rd, 2026.
Ooh, hold on, let me take a look. Yeah, we'll go up the circuit. Okay, but here's the thing: if you take a random of these, where you can see it, how many cases does it take before? Because even though I think the guys have good standing here, in other states, I do remember one attorney who was disbarred. He had over 200 cases before he was declared a vexatious litigant.
This is all Florida?
Yeah. But if for instance, if you take Charlie Altman there, the PDF, so we can see how many cases did it take.
This was sent to me by my my friend who's former law enforcement.
Issued an order. Go up.
Sorry.
I'm not that fast of a reader.
In my attempt to skip over like email addresses and stuff, I sometimes get a little too.
Go up a bit, please. Go up. Okay, so that is just the SAPV state 28. Oh, so they are referring to a 2018 case law. That is good. Okay, so then we know that the case law applied to this is from 2018, which puts the one who cannot be named well within that time span.
Yeah, I wanted to see if the exhibit was his order to show cause.
Recommendable 1, 2, 3, 4, 5.
This was 2020.
5 cases. Okay.
5 cases in.
Yeah. Has had at least 5 actions as defined by this new Florida statute that has been finally and adversely determined against him in the immediate preceding 7 years, meeting the definition of vexatious litigant. Okay, there you have it. 5. In that case, then now it's the severity of the case up and down. You have to read into it, but we do know that 5 cases has been enough in Florida to declare a person a vexatious litigant.
Yeah, okay. This was my these are all.
Oh yeah, okay. We could do. You have that. Wait. Look at that.
These are all.
If you just scroll down, you have Charlie Altman's cases 1, 2, 3, 4, 5. We could just scroll down.
Oh yeah, look at that. 1, 2.
And then you
3,
have
4,
Robert
5.
Audi. Robert Audi's one case, 2 cases.
2 cases.
Armstead, 2017, 2021. Armstead, 2005.
20. Number of cases or circuit 20.
Yeah.
Okay. Date of.
Yeah, but vexatious litigant, that these are all just the ones in the latest.
Yeah. Well, this is just date of court order. So this was date they were declared a vexatious litigant.
Yeah.
So this was the most recent.
That was the most recent. And it only took 5 cases. Okay. Then we know that.
So thought I'd
It is so warm in Sweden now. Now it's
I can do my homework sometimes, but I'm not always good at interpreting my homework.
All right. But let's get through this. Dun, dun, dun.
Change that to make it available. The post-state security covers an opposing party's litigation expenses, whether or not they're a plaintiff or a defendant. Have you understood that? The 2020. Again, I read the
No, I have not understood it like that. I've understood it that a security is there should I file something on you, and the court would have to determine whether I had merits because you have sued me. I am a defendant not wanting to be involved in this, and I'm unemployed because your client called my school and defamed me to my school, losing my teaching job over this.
That's the email I sent you, or the message I sent you.
But no, I am not. I am not employed right now, and I have been hit with this lawsuit as a defendant. And now you're asking for me to post a bond on something I haven't even filed against you.
Lying bitch. Lying bitch. The person who sent the email that she's referring to.
Wait, I can't hear you while this is playing.
So she says that she claims that Jeremy Hales called the school and got her fired.
Yeah.
Not true at all. I know the person who sent the email as a concerned citizen. I sent the email to you in a thing. You can show it. It was DJ Radis. He admits to it fully. And I don't know about you. I don't know if you know this, but DJ Radis cannot be influenced by anybody, good or bad. He does what he wants when he wants. So her saying under oath, Jeremy Hales called the school. Whether you love or hate Jeremy Hales, that is verifiably not true by the email that I was sent multiple times.
Yeah. And if he admits to it, but it doesn't, devil's advocate, more than one person could have contacted the school.
Rosalind Rosalind called the school as well because she heard there was a lockdown and she emailed the school to email the principal and say, hey, was there a lockdown? And I believe the principal, don't quote me, got back to her and said, I don't know what you're talking about. Don't quote me. I could be wrong on the exact wording of the email. However, 2 people emailed the school, both of which admitted to what they did and why they did it. Neither one of which was Jeremy Hales.
Yeah. So, but she has to present evidence for it but again, now this is her testifying under oath. So this is something Jeremy, in his turn, can use in one of his filings. She claimed this without evidence. Da 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 da.
Da 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 da.
Da 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 da.
The exhibits 1 to 8 in the exhibit book and exhibit 2 in the memorandum of law reply as court records, including the public Orange County docket sheets that are available to you and the final disposition entries reflected on those dockets. Or alternatively, you can take compulsory judicial notice of them as court records and official judicial actions.
And Mr. Shockett, Puerto Rico's.
I have objections on the entries of those evidence as they are just they don't prove the truth of the matter, sort of. They are just docket entries with titles. They don't say the substance of what was in those documents. I object on hearsay. I object on the rule of completeness. I object on best evidence rule. and relevance, because again, my actions, and I have case law to provide this court. Am I able to start, Your Honor? I apologize. Am I able to start my?
Yes, your objections are overruled. So go on and begin your presentation.
Objections overruled. Boom, boom, boom. Go ahead and make your argument, bitch. Am I a bad person who wants the judge to do the snap snap?
Nope.
Mm.
I just really wish
Yes,
this
Your Honor.
judge would.
Okay, so the plaintiff has cited 3 civil cases, 4 injunction cases, 1 guardianship case, and a federal case that was never noticed in his amended complaint, although he says was in his memorandum, but a memorandum is not meant to amend an actual motion before this court. So I was not notified to that until today that he intended to argue that. And I would have an issue with due process on that. First of all, I have done absolutely nothing that was not in good faith.
Under memorandum of law, it's under the judge's discretion to bring it in. She can object to it, but it's up to the judge.
Everything I have done, no court who had jurisdiction to those cases ever found me to not have done something in good faith. Those are the courts that had jurisdiction over my cases. Those were the courts that were able to decide whether or not something had merit or it didn't.
Is she claiming that this court doesn't have jurisdiction? Wow. Yeah, that will go swell.
And that's where I'm sometimes
that
like,
is handled pre-trial, bitch.
Well, I always describe
and you have to file for you do not have the jurisdiction. You have to file for that.
I always describe it like the bad like the medical documentation. If it's not in a document, it didn't happen. Yeah, correct me if I'm wrong as a non-lawyer, but if it's not in a document, the judge can't go searching for it. But if Randy puts it in a document, like he put the link for the interview she did where she literally admitted to filing things just to get him on the record, then the judge has jurisdiction.
Yeah, he just asked her to take judicial notice. And that is under the judge's discretion. So not only did he have it under the memorandum of law, he did ask her to take judicial notice of it, meaning it's not entered as evidence per se, but as supporting evidence. More, I don't know the English wordings of it, but so he covered his bases twice, and now she can still object to it, but it's under the judge's discretion, and she kind of overruled already.
And I'm kind of wondering what Kyle Fletcher thought of this, just knowing some of the filings that he's done against her and reading some of his filings. I never read them on stream because I didn't want to. At that point, she was getting boring because she quieted down, and if she quieted down, so did I. Because I'm petty, but I'm not bitchy necessarily. So when she stopped talking about me, I stopped streaming about her because she got boring. And I wonder what Kyle Fletcher, because he didn't need to be here. He is here as an non-party observer. I'm wondering what he's thinking of this and how he knew about this. My brain just goes in a million directions, wondering what he's thinking.
Da, 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 da. And again, if this stream would be taken down, I posted the link to the Rumble stream. Because they don't give a fuck about what she says and files.
And no court by jurisdiction have ever found such. To find that I didn't file these in good faith, this court would have to go back through every one of those cases, read every one of those pleadings to decide whether or not they were made in good faith, not just reading titles in a docket. Again, there was no adverse and final decisions. There was one in an injunction case. And the reason that that was not granted permanently was because of the attorney-client relationship. That's what the court had stated. If you actually had these orders in your hand, you would see that there was nothing, no court order ever saying that my case was dismissed with prejudice or that my case had no merit. The only court orders were the ones either adopting my voluntary dismissals or saying that I needed, that I didn't perfect the service in time. But anyways, I'm going to go ahead and go on. Under Menendez versus Progressive Express Insurance Co., a 2010 case, the central focus of the Florida Supreme Court's inquiry into whether a statute applies retroactively, which is essentially what Mr. Shockett is trying to do, is whether that retroactive application of statute attached a new legal consequence to events completed before its enactment.
And apparently that has already been decided, because we just saw a case that spanned over past 2025. So good luck on that.
There are definitely new legal consequences for events completed before the enactment of this amended statute. It looked at the facts under the original statute. This case on its hands would be dismissed today because there was not 5 civil cases that met the criteria under the original statute that I was on notice of when I filed my cases. Today, plaintiffs are attempting to have this court sanction me under a new amended statute as a vexatious litigant, which would entail new legal consequences on any lawsuit that I ever filed prior to the amended statute, when these lawsuits, again, were never found by any court who had jurisdiction to find such, find me ever vexatious or frivolous, or anything finally or adversely determined. It is clear that the issue of retroactive application of the amended statute.
Yeah, she's reading something. Yeah.
She's reading her motion.
Yeah.
That's word for word. Approximately the motion she wrote and submitted to the court.
Yeah, which, I mean, she can. I don't know if it helps, but it's all under the judge's discretion.
I don't see the point.
Sorry, what to say?
I don't see the point in it helping. The judge has already seen that. Wouldn't you use oral arguments to bolster what you already wrote, not repeat what you already wrote?
A good litigant would do that, yes. She's not.
Prior to presenting evidence to satisfy the new amended statute, when I argued these events took place during the original statute. Retroactive application requires a 2-pronged test. When there's 2 Florida Supreme Court cases, Florida Insurance Guardian Associate Inc., the Devon Neighborhood Association, a 2011 Florida Supreme Court case, Menendez v. Progressive Express Insurance Co., which I've already cited. They make clear to retroactively apply an amended statute, which is essentially what is being done here. There's a 2-pronged test. The first is that the court must ascertain whether the legislature intended for the statute to apply retroactively. There must be clear language. The 5th District, in the 5th District of Florida, the case law Campus Communications Inc., the Earnhardt specifically states that legislative intent must be determined primarily from the language of the statute. It must be clear and unambiguous. It must be clear and definite. They go on to show an example. In the instant case, the legislature was clear in its intent because they twice expressly stated in the amended statute that it was to be applied retroactively in that clear language. In the new amended statute, no such language exists. So for that alone, the first prong fails. And if one of those prongs fail, you cannot apply retroactively. The second prong is if the intent is clearly expressed, the court must determine whether retroactive application would violate constitutional principles. Mr. Shockett tried to lead this court to think that this amended statute was just remedial or procedural. However, that is not such. Even in the case law that he has provided to this court, makes clear exactly what is substantive versus what is remedial and procedural. On prong 2, so it fails because the amended statute is substantive, and it's substantive if it affects a vested right, which I had a vested right at that time to file those lawsuits without the fear, especially the injunctions when I was going for my protection, that would work against me and deem me a vexatious litigant, or if it creates a new obligation or imposes a new penalty. Well, it clearly creates new obligations and it clearly imposes more penalties. And I can show you the exact language in the statute that brings it to such. It's under Menendez, again, Progressive Express Insurance Code. Moving on, examples of cases that have been found that Mr. Shockett cites in his own amended, his memorandum of law. These are cases that were not allowed to be applied retroactively. In Young v. Altanas and in Matthews v. Pullman, a statutory requirement that the non-prevailing party pay attorney fees is a substantive change. Retroactive application to actions that occurred before that amended statute cannot happen. It would be deemed unconstitutional. Another example in Gupton v. Village Key and Saw Shop Inc., an employer's effort to enforce a non-compete agreement after a statutory amendment changed the governing law constituted a substantive change affecting a vested right. Under Carmel v. Texas, a 2000 case, the Florida Supreme Court, or the Supreme Court in that case, held that a statute permitting conviction of sexual offense is based solely on the victim's testimony when previously corroboration was required constituted a substantive change. Such an amendment which reduces the quantum of evidence required for a conviction, which clearly in this case, the evidence, it opens the door to taking in family law cases that I could have never anticipated would ever be used against me at those times. In Carmel, the changing evidentiary requirements for treason. This was in Carmel, Texas. It was also cited in the Fenrick case. Changing evidentiary requirements for treason convictions after the alleged crime occurred. That law's reduction of evidence required for conviction was held 13 to be substantive and not allowed to be applied retroactively. On docket number 75, which I have also submitted to this court in judicial notice of the Florida House of Representatives final bill analysis, and comparing the wording using both versions of 68.093, both the original that I was operating under and the amended version changes in the following ways. It increases the range of cases that can be applied, now applying family law cases. It redefines how a pro se litigant is determined. It expands the look back period. It allows state and federal cases to be assessed. It allows the court.
How many here believes that the judge has stopped and is simply answering emails and writing up a grocery list? 1 for grocery list, 2 for answering emails, 3 for making memes to be published at X. And if you think 3, send me what you think her memes are on X or on my DM and post it as an answer to one of my tweets. This judge has listened enough.
I think
Gwendolyn says 1, 2, and 3.
Megan and Tug last hearing that I didn't attend, but they did, described her as a fish from a Disney movie or a Pixar movie, where it was like the fish that, like, oh my god, I can't remember the name of it, but because I'm cognitively impaired, but at the same time I'm like, it fits so well. Like, it fits so well. Some of the people in chat who watch that stream will be able to tell and have a better memory than me. But remember that fish in that movie, like that Pixar movie? It's the clownfish, but there's a name there. Oh, Mr. Limpet. Jaws. Mr. Limpet. Oh,
I have no idea what that. Your American cartoons are quite different from our Europeans. Now, I haven't watched cartoons really since Tom and Jerry, and those were fun.
Trying to see if I can find just a good picture.
I mean, I was in my 30s when the cartoon was. What was it? The cartoon cow and Weasel, who had half human as parents. I mean, literal half humans. You could only see from the waist down.
Let's see. Image.
Cow and something. Yeah, whatever it was.
Hold on. I'll share my screen with you real quick. You have, once you see it, you can't unsee it. So I'm sorry for what I'm doing right now.
Oh God, no.
DreamWorks. Lola from Shark Tales.
Oh no. Oh no. Yeah, thank you. Cow and chicken. But I was in my 30s when that came out. I mean, when I was a kid, my cartoons were more or less black and white. And Eastern European cartoons, because socialist country. Professor Balthazar, for instance, and stuff like that. What else? Yeah, but mostly common was Tom and Jerry and Donald Duck and stuff. Over here, Donald Duck is more popular than Mickey Mouse. My favorite of the Disney cartoons? Goofy.
Goofy. I love Goofy.
Oh. Yeah. Dun, dun, dun.
Court to impose security against vexatious litigants, regardless if they're a plaintiff in the case. It broadens the sanctions available against vexatious litigants. Once determined a vexatious litigant, a court can now deny their request for relief, strike their pleadings, render a judgment by default against them. Further, the amended statute clearly says if a litigant in good faith filed what they filed, they cannot be deemed vexatious litigant. So the court would have to go through all of my cases when no other court that had jurisdiction to do so ever found these to be bad faith. And this court would have to determine whether or not my filings in my cases were done in good faith. That would require me to present testimony and give evidence. And one of the reasons why I said 30 minutes was not enough if the court did not determine which statute is going to apply. Thus, similar to these cases cited, this is a substantive change. The amount of evidence to determine when vexatious is changed, allowing more sanctions to be imposed on past actions under the original statute, using actions where the defendant's vested right to litigation in these cases at that time, I had that vested right to not fear that was going to be used against me, would have never placed me on notice in any of these cases that I would be up for sanctions as a vexatious litigant when I filed such. The defendant has vested interest and rights when I filed my 4 injunction cases for my protection without believing that somehow this would end me up as a vexatious litigant. The amended statute creates new legal consequences to defendant, impairs vested rights, creates new obligations.
I just remember, this was not a cartoon, but this was around when I was a kid in a socialist country. Hand puppets. Yeah. It's a koala and an alligator. Jenna and Drutten. Yeah. We also had a children's program called Lost in the Pancake.
Bye-bye.
Yeah. Oh, hello, Mini Squid. Hello.
Hi.
Hi.
Tammy, you're older now.
How old are you?
4.
4.
Wow.
Yeah, I start school on Monday.
Yay, starting school. That would be so much fun. Giving mommy some vacation.
Yeah, you're gonna be a big girl on Monday?
Yeah.
Okay. Okay.
All right.
And imposes new penalties. Remedial in Mr. Shockett's own memorandum of law. What it means to be remedial is defined in State v. Kelly. Means for enforcing existing rights does not disturb substantive rights or imposes new liabilities. Statutes granting the state a right to appeal a judgment of acquittal, that would be remedial. Emphasizing the right of an appeal is remedial. A new procedural bar, according to Tradaha v. forfeiture, that would be remedial. The Florida Supreme Court in this, the city of Orlando v. DeJarens says statutory exemptions for attorney-client privilege, that would be remedial. Village of El Porto v. City of Miami Shore states deadlines would be remedial changes. None of that are what is applying today with the attempt to get me deemed a vexatious litigant on a newly amended statute for past actions that occurred when the original statute was into play. Plaintiff's argument still fails under the application of the amended statute. So if this court...
Oh, thank you, Granny Smith, giving me 1,000 joules. I have no idea how much that is, but thank you so much. Thank you. I heard somebody say $5. I heard another one say $10. I have no clue.
I heard 1 cent per joule.
1 cent per joule. That would be $10. So thank you. And again, a reminder, if this stream gets taken down, either for during the stream or for replay crew, go check Rumble. On Rumble, I am Big Nick. Just check for Big Nick. And that is thanks to Cat Not Williams, because there's a lot of Nick going around. There was, you know about Nick Rekieta. Then there, in the case that we both covered, there was another Nick. So it was, I'm Big Nick. So that is what I am on Rumble. Somebody says drink. I don't think we're there yet. I have to check here. I mean, Dave got one full. He paid for that. That one got, because of that one, we have that one and that one. That's 5. And if that is 10, we are at 15. So another $10 before the next spin on the wheel of shots, or wheel of half shots. That's 3 left. Glitter fizz, apple pie, and coffee.
Even were to go to the amended statute and apply that statute, it would still fail. It would fail for the following reasons. There was not 5 cases.
You asshole. Thank you. All right.
This isn't the first time I've been called an asshole, and it won't be the last.
Here it is. It's 1 of 3. Glitter fizz, apple pie, or coffee. And Dave also sent a tenner, which means we are 15 towards the next spin. And apple pie. Now, this one is a bit scary because there is literal no time in history that a booze that claims apple pie actually tastes like apple pie.
Hey, I make a damn good apple pie moonshine. Thank you very much.
I've tasted the old smoky apple pie moonshine.
Actually, I don't. He does. But...
Yeah. I tasted the old smoky rendition of apple pie moonshine. Oh, hell no. We are going back to Utah. For half a shot. Cheers. And that's nowhere close to apple pie. It's a slight sense of cinnamon.
If you ever make it to Savannah, I will give you. When I know you're coming, I will make the dude make apple pie.
Oh,
it's Everclear, apple cider, cinnamon sticks, and it tastes like apple pie.
Oh.
It goes down like water. And it will get you buzzed in no time.
And thank you to Kmart Red Queen over at Rumble for a $10 Rumble rant. Yay! Now we're just $5 from the next spin.
Keith's comment is so accurate.
Money here won't be lost, lol. Yep.
I get the feeling Baby Squid will be just fine. Mama Squid may need a minute and some hard liquor. That was that. And I have one more Seagram's, and that's the only thing we have in this house besides a bottle of wine that I'm saving for my sister-in-law. Whenever she is ready to drink it, I will be ready to drink it.
Oh.
Because it's a bottle of wine I spent $40 on.
That were finally and adversely determined. The defendant has, I had representation in 2 of those civil cases. In my response, I gave tables to make it very easy for this court to look at the cases to see exactly whether the criteria was met. And all of these cases were filed in good faith, where no court who had jurisdiction at that time ever found them to be frivolous, meritless, or in bad faith. For this court now to go back through my unrelated cases under different jurisdictions of outside courts would be not only improper, it would require a full evidentiary hearing for my due process to be able to present evidence and testimony to prove that every one of my cases, giving the court the liberty of looking at all the filings, was made in good faith. This is not a question. This is mandated under Florida Supreme Court law. As far as Mr. Shockett, in his memorandum, he attempts to mislead the court on several cases, specifically Milcalvi v. Kismet, Inc., where he states that the statute of limitations running is an adjudication on the merits. That is completely false. I read all those cases. There's not one case that has said such. What that case did say is exercise of rights to voluntary dismissal terminates an action without prejudice, meaning that the action may be refiled at any time with an applicable statute of limitations.
Yeah. As Roy Lonsfield says, she doesn't have this judgment against her because she dismissed them voluntarily before they were heard. All of them were dismissed by, well, maybe a couple.
She had a couple.
There was an actual judgment.
She had a couple that were dismissed because she didn't show up for hearings. She had a couple dismissed because she didn't perfect service. She had a just, and this is only in Orange County.
Yeah. Yeah, this is in this jurisdiction alone where so the cases he is submitting all the cases from that county, I assume. But yeah, she avoided being called out because she voluntarily dismissed them or asked for a voluntary dismissal, which by its nature will be without prejudice.
However, costs in dismissed actions are to be assessed and judgments entered for cost of that action. At no point did it say just because the statute of limitations ran that was an adjudication on the merits for adversely and final ruling from a court. There was no language in any of the cases that he cited. None of my cases, civil cases, were never adversely or finally determined. I had representation. I had one injunction case where it was dismissed.
And there it is. Another $5 from Brain Socks. Brain Socks. Brain Socks has been faithful to my Rumble channel forever. Thank you so much, Brain Socks. Thank you. And now it's a 50-50. Glitter fizz or
glitter
coffee?
Fizz? What is glitter fizz? It just sounds so wrong. What is it
Glitter
supposed
fizz.
to be?
Yeah, but the label is glittery. The booze isn't.
Okay.
I have because there's no actual. There's nothing saying what's in the damn thing. But see here, dun, 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 where we end up. There it is, and it is glitter fizz. And it's a half shot.
What's it supposed to be?
I have no idea. Let me see here. No, it doesn't say anything on the shot. So I have no idea. So here it is.
Well, they really are half shots.
Oh, it smells sour.
You're a brave man.
Yeah. Yeah, no. It is. You know how dishwasher lemon scent smells? That's
Yes.
what this tastes like. Yeah, it's not good.
There's a shot called a lemon drop that I had back in the day that I'm pretty sure is that same thing.
Well,
it tastes like what lemon dishwashers detergent is supposed to smell like.
Yeah. That wasn't pleasant. But now we are down to the last one, which is coffee.
That's got to be like a Kahlua kind of a thing.
I wouldn't bet on it.
Good point.
But we will see if we get there. We will see if we get there. That's $25 via Super Chat, Rumble Rant, gifted memberships, Buy Me a Coffee, or PayPal. You can find the link to Buy Me a Coffee and PayPal in the description.
For a permanent injunction on the merits. On the guardianship case, that was an appeal. I was initially the attorney of record, and that case stemmed from a 2019 case. The plaintiff attempts to bring in the federal case that was dismissed after I retired my license, changing my standing, which was the reason that it was dismissed. However, this is a due process issue, as Mr. Shockett never alleged this in his amended motion. Memorandums of law amend motions and add new facts. So that was never alleged. Requesting a bond is not right when I haven't even filed a lawsuit. I'm a defendant in this lawsuit. I have not filed one, and this court would have to determine not only that I was vexatious, but they would have to look at the substance of what I filed to see if it had merit or the likelihood of.
Full shot to cleanse your palate. It's TST. All right. And as a 50-bucker, you choose my poison. And I have different kinds of whiskeys. I have different kinds of tequila. I have gin. I have vodkas. I have. This is really good. Old Smoky, salty caramel. That is so nice.
AKA, don't choose that because this is supposed to be the wheel of regrets, not.
Yeah. I also have Red Cap tequila at the other end of the spectrum.
Do that.
I also have.
You see, you're too nice.
I have good tequila. Dealer's choice. Pick your favorite. Well, at the moment, wow. At the moment, let's see if I. Oh, this one. Folks. This one here. I bought 2 years ago.
Oh, that looks good. The bottle looks like it would look good.
Yeah. This is Varchas. Straight bourbon whiskey finished in port wine casks, limited edition, 111 proof. This here is not on the market. I bought this at the distillery. Me and Dave went to the actual distillery. And the only regret I have is that I didn't buy 2 bottles, because this is bottle 120. Let's see here.
We figured out who Lips is
Well,
trying to look like.
Yeah, it is really a limited edition, because I do think, it was 72 barrels in total.
I shared a screen with you. It's who Lips is trying to look like.
No, I see this.
It's the woman with the world's largest lips.
Where?
In the...
No. Where? It's 2 a.m. where I am, and I had a few. But
I had an entire bottle of wine. You know when's the last time I drank an entire bottle of wine by myself?
Yeah. But as you said, I don't have much left.
To eating the...
It's not much left. This is an absolutely breathtakingly good bourbon. Hello! Mini Squid is here again. I'm taking a clean glass. And I'm actually choosing, because Nick's Bar in Miami. I thought that was fun.
You want to go to Miami?
Yeah. I want bye-bye. Emmy. Mommy, I want Emmy.
Miami?
Yeah.
You want to go to Miami?
Yeah.
Yes! Miami is amazing. They have alligators in Miami.
We have alligators here.
Yeah, but Miami has the real ones, not the fake ones you get up there.
And I had an alligator chase me. So the first time I went hunting with Mr. Squid, he leaves me in the woods by myself at 4 a.m.
Yeah.
And he's like, if you see green eyes, run.
Oh yeah, definitely. I mean, even the small ones, no. But thank you so much to Testes. No. Which I translate to testes. Sorry, I'm so stupid. Thank you.
Water.
For giving me the opportunity to take what is more or less the second to last or something like that from that bottle. Thank you. Oh, it's so good.
Hey, Angel, you have Daddy's phone.
Mommy's not.
Where is mine?
I know.
Can you go get mine, please?
I have to find another one of those bottles on an auction or something.
Attack?
Is Baby Squid holding a shotgun shell?
No, she's holding a lip gloss.
Oh, okay. Thank you.
Give it a year, then it'll be a shell.
Yeah.
Oh, whatever you do, no one send. So look at Tammy E's comment. Whatever you do, no one send a.
No, I absolutely not. Nope. No.
I did show Nick Mary Beth. He would not show it to the. He would not show it to everybody else. You're fine.
Yeah. That looked like a baboon's ass. Just saying.
So did your script. I mean, your thumbnail, it fit. What you do is you show it. Then when someone decides to privacy complaint your stream, you'd be like, I was talking about this lady.
What?
Just can't.
Yeah.
My eyes. Can I have some of that? Okay.
Oh, let's continue.
Actually prevailing. Mr. Shock brings in audio recording. partial audio recording of me that's not authenticated. It's not even dated. We have no idea what the full audio was because that wasn't submitted. So I would object on the hearsay. I would object on the rule of completeness. I would object on relevancy. I would object on lack of authentication in considering any of that testimony that he claims that I did. That was not a complete rendition, nor was it even dated. I would ask for all of my exhibits to be entered. They were not.
Why would she's trying to tell the judge, my words doesn't count because it wasn't dated? No, judicial notice. What was he asked for? Judicial notice. That also has to.
Not that it came from like my own words, and
Yeah.
you know.
So she's trying to. That's a Hail Mary. Oh, it wasn't admitting properly brought to the court. So please don't listen to my own words. Yeah, it's a bit of good luck for that.
Shut up, sit down.
Derek is back. Derek has been a supporter and a member and for as long as I can remember. Thank you so much, Derek. He's also a monthly via PayPal, which is amazing. Yes, if you didn't know that, you can be a monthly donor via PayPal. That's an option you can have over there. And PayPal only takes a 5% cut, while YouTube takes 30%. Now, you don't, via PayPal, I can't give you early access or emojis and stuff, but more comes to me. So thank you, Derek. Thank you so much. And Derek, I'm happy you're feeling better. Member for 20 months. See? 20 whole months. Thank you so much.
Objected to, and Mr. Shockett, part of those exhibits are I'm one of 13 defendants who Mr. Shockett has sued over the last year. 9 of those defendants have been dismissed with prejudice for failure to state a claim against Mr. Shockett and his client. They have made a habit of, they have 13 people they've sued this year. They go on YouTube, they make content out of it.
That's not this case, Miss Baboon Ass. It's not this case. Now this here, what she does, even though it might be true, this is slander.
That's me. I make content out of her and her stupid self because she called me a felon.
Yeah.
But that's me being petty, but also reading public documents, and reading public documents is not against the law. And if I want to use that as content, that is my free will to use that as content. So suck it. Unstickle.
Yep. So this is just, and it's not the lawyer who submits, it's the client who submits. You acting as your own lawyer, then it's you who submit on your own part. That's the difference.
Harass, and
or one of the differences.
Like I said, 9 of his lawsuits were dismissed with prejudice. That's an Exhibit A that I entered into my hearing binder. If you would like to look at the report and recommendation.
Are those against you?
But still, one case, 9 defendants.
Yeah.
I don't, like I said, I'm not a Jeremy Hale supporter necessarily. I'm just to call it like a freaking see it kind of person. But like one case number, 9 different defendants. That is not one case or 9 different cases. That there's a big ass difference there. Also, Jeremy Hales has a lawyer. So by the definition in the statute does not make him a vexatious litigant. You don't have to like him. Like sometimes like him or hate him, the facts don't lie. And then this is one of those cases where the facts just don't agree with her.
Yeah.
one
tries
case.
to. This is pure deflection because it's that case. She's not involved. It's pure deflection.
Of that. This motion that he brings is done not in good faith, but in bad faith. His clients have harassed me for the last year, defamed me, ruined my teaching job. Just last night went crazy all over YouTube, calling me a vexatious litigant, making fun of my appearance, calling me lips. I have gone through extreme cyberbullying over these people.
She calls
and
herself
he wants to
lips.
silence me now so that I have no remedy for help. I have had 4 police reports on this issue. Mr. Shockett has 7 current pending bar complaints from other
Police reports are not evidence. Testimony from police are evidence. Anybody can file a police report. It doesn't mean it's true.
various people showing his connection with the harassment from these YouTubers. And again, this court, for this court to find me a vexatious litigant under either statute would require me more time. I am prepared. I have given Mr. Shockett a list of 8 witnesses. I am prepared to bring forth all of my filings if this court should believe they have jurisdiction now to go.
8 witnesses? I don't remember 8 named witnesses.
She wanted people like Luthman, Fleabag, them kind of people.
Oh, yeah, good luck.
But she also says like people are harassing her by reading her own words.
Yeah.
If you don't, I always tell her on my streams, if you don't want your dirty laundry in public filings, don't put your dirty laundry in public filings.
Yeah, it really isn't hard. No,
like I would sure as hell love to sue my mother-in-law for emotional distress.
Yeah,
but
yeah,
logically having a case and wanting my dirty laundry on a public record are 2 different things.
Yeah, me and Miss Viking, we go on separate vacations because Miss Viking's mother, my mother-in-law, she likes to join. Miss Viking likes to go on cruises. I'm not a big fan of cruises, but I would definitely go with Miss Viking on cruises. It's just that every time we have gone on cruises with mother-in-law, she's in an adjoining room with a door in between. And for me, that's a, oh, hell no. Oh, hell no! Because I like Miss Viking a lot. And I don't want mother-in-law in this paper-thin wall on the other side while I'm very, very much liking Miss Viking.
Well, let's put it this way. I've seen my mother-in-law more than Mr. Squid has in the last 3 years.
Yeah.
And that's purely by accident at Walmart.
Yeah. So for instance, 2 years when I drove through United States. No, last year when I went first to Utah and then to Miami. Me and Miss Viking, we had a few days together, and then off I fucked to Utah, and Miss Viking went on a cruise. And we did that. I mean, we do that all the time. I mean, she's off to the Mediterranean on a cruise with either mother-in-law or the boys, and I'm off to somewhere else. And we spent a week together with all the families, and then to avoid murder, we're
no contact. We're no contact. She had a first birthday party for this one. Didn't invite me or Mr. Squid.
So she decided to have a birthday without the child's mother.
Or father.
Or father. Yeah, fuck you. Seriously.
Yeah, I have a whole members only stream about my mother-in-law issues.
Keith over at Rumble says, "How are you and Miss Viking supposed to smash when mother-in-law is next door?" Yeah, we didn't, because mother-in-law was next door. That is why I don't go on a fucking cruise with Miss Viking and mother-in-law.
So the thing I secretly love that I get a kick out of is every time they have to come to town, they secretly pass my house and don't even know it. Like, we moved to this town.
Oh.
They have to literally pass my house every single time they come to town, and they don't even realize it.
Oh, nice.
It's like this little piece of like petty in the back of my brain, and I know it's so wrong, but it's so funny to me. I don't know.
Oh. All right. How much is left here? Not much.
3 minutes.
The courts that did have jurisdiction never found such. Mr. Shockett fails to give 5 cases that were finally adversely determined against me. Even with
Because you dismissed before the court could even hear them.
Well, she still seems to think that adversely and finally dismissed against her is the only thing that qualifies her as a vexatious
that's not
statement.
the new that's not the new law. I mean, and I don't think the old was either.
It's just that's not the only. Oh, she's a headache in a bottle.
With the amended statute, there's not 5 cases that were finally adversely determined against me. I'm allowed to voluntarily dismiss something. I don't like the court, if you wanted in my opinion, but I have been under a horrendous amount of attack since I retired my license. I have not been happy about it. It's not something I want to do. But at the same point, I go to the police and they say, we got to take it up civilly. I'm currently unemployed. I would love to have an attorney. I just don't have the money for it because Mr. Shockett.
Not a fucking lawyer in Florida would take your case.
So, funny story, her husband was representing her until about 3 weeks ago.
Oh, really? Oh,
so there has been questions on whether he had to stop representing her.
Because in this case, he kind of had his interests were different than hers. Because
however, for her to say that I would love to have an attorney, technically you had one.
Yeah.
His client called my school defaming me and ruining that job for me in November of 2025. So I would ask this court again to consider everything. I don't think that this meets the criteria. And I would ask this court that if before ruling, if this court believes that they need to implement the amended statute, that I'm given a full day hearing to bring in evidence and testimony to prove to this court that nothing I did was done in bad faith. It was always in good faith, and there's no court that ever found me as such. Thank you, Your Honor.
Thank you. Briefly, Mr. Shockett.
Thanks. I was going to ask for a brief thing. So, Your Honor, Ms. Federigos is apparently traveling under the wrong assumption. The definition of a vexatious litigant has multiple definitions. We're not traveling under the 5-case one. The evidence is clear, Judge. Summation. This is summation. Ms. Federigos is a person under the statute, not under the 5 or 7 years of cases. She repeatedly files unmeritorious pleadings or engages in tactics, such as we heard today, solely intended to cause unnecessary delay, and that makes her a vexatious litigant under the statute. She's a person, the evidence just shows she's a person who repeatedly files pleadings, requests for relief, or other documents that have been the subject of previous rulings by the court in the federal case, and that makes her a vexatious litigant under the statute. Lastly, Judge, she's a person who repeatedly files unmeritorious pleadings, requests for relief or other documents, conducts necessary discovery, and engages in other tactics that are frivolous or solely intended to cause unnecessary delay in court actions. And that makes her a vexatious litigant under the statute. So, Judge, what we're asking you to do is to declare Ms. Federigos a vexatious litigant under the pursuant to Florida statute, section 68.093, enter a pre-filing order prohibiting her from commencing any new pro se action anywhere in this circuit without first obtaining leave of the administrative judge, We also ask that you require her to furnish security in the amount of $37,000 to cover plaintiff's anticipated reasonable litigation expenses, including attorney's fees and costs, and grant any other relief, Judge, that you deem just and proper. Thank you, Judge.
All right, thank you both very much. I do have to make written findings regarding my ruling on that, and I will do such. So I will take the matter under advisement so that I have enough time to be able to write that ruling out. Thank you both very much. Have a great day.
You too. Thank you, Judge.
Yeah. Now, does this case have merit? Absolutely. Will it get her to a vexatious litigant? There is a chance. But honestly, I think it needs more.
It could go either way.
Yeah, it could go either way. It depends on the judge. If the judge wants to set or ask, more or less ask through her ruling for an appeal. Now, both parties will appeal. I'm certain both parties will appeal. If it goes against Miss the name we cannot name,
Voldemort,
she will appeal. If it goes against the other, they will appeal. So this is up, regardless of the decision from the judge, it will be appealed.
And this is where both sides going, my side's gonna win. I'm like, you don't know that. It could go either way because this is the judge's discretion at this point.
Yeah.
And how she interprets the statute.
No.
And
Now, I don't know the other cases, just that we looked at the amount of people who has been declared vexatious litigants. I have to read through those cases, but my experience from other states where it demands like hundreds of cases, I would say it has a low chance of succeeding. But with the new 2025 amended vexatious litigant law, I don't know. It's all up to the judge, and regardless, it will be appealed.
And I think technically speaking, it meets the statute. But if there's one thing I've learned following cases, just because something technically meets the statute doesn't always mean you get your way.
Exactly.
But the only reason that I hope this fails or this succeeds and she fails is if she fails and she gets labeled a vexatious litigant, then I don't have to spend any more money on my damn lawyer, and I can tell my lawyer, thank you very much. We'll be in touch, but I really hope I don't have to pay you anymore because my lawyer is not cheap.
Yeah. So if I would give an honest assessment, I would have a hard time getting above a 10% chance of winning this.
I mean,
my personal wishes aside, I would love for her to be declared a vexatious litigant. But with the cases I've seen otherwhere, who are so much worse.
And there's always a difference between what we want to happen and what actually does happen, or what we ethically and morally think should happen and what legally should happen.
Because this new vexatious litigant, I mean, if it's 5 or 7 cases, out of how many also? Because if you are a serial litigant, you will always have, in a 5 to 7 year span, have 5 cases that doesn't go your way. Yeah.
But here's my ultimate question. If this doesn't work out, and say she files suit against me, would that be a 7th or an 8th or whatever would that case add up to it?
I don't give legal advice because I can't give legal
obviously.
advice. But even if I could give legal advice, this is not legal advice. It's up to you and your lawyer.
It was like, it's just one of those things of like, it's just weird because that's one of the reasons that I care about this is because I have a personal monetary stake in this at this point because I've spent thousands of dollars on my lawyer already.
Yeah. And that's the whole thing, that people who uses the loopholes, they know it by they know, as you saw, everything she did up to 2025 was to scour the edge of the previous. And but again, I mean, look at Laura Owens, how many cases and how long she has done the shit she has done. And nobody's even close to asking a judge to declare her a vexatious litigant.
However, the state of Arizona is borderline calling her a felon. Borderline. Not yet.
Not yet.
But possibly.
Yeah. But even as a felon, she can still file lawsuits.
True.
Yeah.
That's true.
Oh, Mr. Jingles is here. Hello. Hello, Mr. Jingles. Oh, yeah. I bought Mr. Jingles something.
Oh, what'd you buy him?
Which I've been trying to get him to use for the past 2 weeks. Let's see. Stay up there. No. There, up there. Where do you go? Hey now. I got him a strawberry nest.
That's a strawberry? Looks like a pumpkin. He's using it.
Get in there.
Maybe. Okay, never mind.
Nope.
I was gonna say he's using it. Never mind.
Yes, of course it's a strawberry nest.
It looks like a pumpkin because on camera it looks orange.
No, it's pink.
Okay. On camera it looks orange.
I tried. Now, Mr. Jingles has this climbing tree. He has 2 other climbing trees around the house. He has these scratch poles, 2 of them. No. Cardboard.
I mean, why spend money when you can like get an Amazon box and
yeah. I try, but he has literally no interest in toys. Yeah, this thing is sprayed with catnip. No, won't happen. And now we won't even go upstairs. Oh, really? Oh, look. Oh,
thank you, Mr. Jingles.
go in there. Go in there. Oh, just
So
putting
close.
his head in and ass outside, looking for treats. That's all he does.
Butt.
Yeah.
Say, at least my butt's cute.
Wow. Yeah.
Say he might not like to snuggle, but at least he allows you to pet him. My cat was like, "Don't touch me."
Yeah, but this one, it's like from a distance. Yeah, if I try to hug him, I get scratches. I even put, because he loves, if I do laundry, And I have, for instance, I have my marine suit, marine colored suit, because that has to be dried flat. Guess what he does? I just stretches all over it. So I did try. Okay, I do laundry with that detergent and everything, and I put one of my shirts in there. No fucking interest. No, none.
Only the good stuff.
Yeah.
Only the good stuff.
Yeah. Hey, Chris. Thank you.
We had a dog take up residence on our back porch for a day and a half. So he was lost. Poor guy.
All right, folks. It is 2:20 a.m. where I am. We watch through the one who cannot be named hearing regarding declaring her a vexatious litigant. Do I believe it will be successful? I want to. I don't think so. There's just not enough. You need a history of like a dozen cases, or a handful of extremely serious ones. These, I don't think it's going to cut it. I'm sorry, I don't. But you never know. It's up to the judge. It's up to the judge.
The only thing that might be on the side of labeling her is the fact that she's got it on video in an interview saying, "I file lawsuits to get them on record." That's not very often that happens.
No. Now that is that is probably the strongest evidence they have, because people filing suit and then dismissing it's not uncommon. Sadly, it isn't. But we will find out eventually. The judge will take it under advisement. You never know. But regardless, he went in and out again, at least.
Now his butt's in and his head's out.
So now his butt is inside and his head is out.
Anymore.
Okay, here he is. Yeah.
Hey, but that was progress.
Progress. Folks,
you did it.
Thank you. Thank you so much. You have a glorious, continuous Friday. I'm going to send you over to Shizzy. And I will be back on Sunday because tomorrow a niece has a birthday. So nothing on Saturday, but on Sunday. Let's see here. Somebody sent me something. I just have to find it. Dun, dun, dun.
All right, I'm gonna take off. I'm gonna get the little one to bed.
Yeah, good. So Thank you so much. Thank you. Thank you for being here.
I hate this woman. Like, the future of my pocketbook relies on that hearing. I know. It's sad. All right, have a great night, everybody. Bye, guys.
Bye, guys. Thank you. But on Sunday, for fuck's sake, where is it? Dun, dun, dun. Dun, dun, dun. There it is. Yeah. The Donna McNamara versus Stoughton and Carter amended complaint. That is a part of the Sarah Birchmore case. Chief McNamara is suing the town because Chief McNamara tried to clean out the Stoughton police force from these bad elements. And the city council and their town manager did everything to just go away, and it backfired. So she has filed an amended complaint. And on Sunday, we will go through it. Again, thank you so much. Thank you to Widget for 250 euros. Thank you for Wim for being a member for 36 months. Thank you to Emotional Lemonade for becoming a member. Thank you for AK the Cat Lady for $2. Thank you to Auntie M, $5. Thank you to MLS for $20 and $50. Thank you to Granny Smith for 1,000 euros. Thank you, Squid, for $10. Dave for $10. Testes for $50. Thank you to Derek for 80 euros. Thank you to Derek for being a member for 20 months. And thank you to KMX, Red Queen over at Rumble for your $10 Rumble rant, and to Brain Socks for a $5 Rumble rant. Thank you so much, everybody. I'm going to send you to Yeezy, and I will see you all here back on Sunday. Thank you so much. Have a good one. And remember, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Bye-bye.
Santa Claus, riding in with the winter Lord.